But under compelling circumstances,
Yes.
under compelling decretal court, appeal court has confirmed the decretal court's eviction order, saying 2 months time period is given on 31st July. 1st August, decree holder moves an application ex parte, gets an order to break open the padlock before that 2 months period. The next day is 20th August. Today or tomorrow they will break open the padlock. Next day, ex parte they move. But it is not there in the list. But we had filed it on 12th. But now
What is the date you have given?
now it is being told without 18th they will 18th it has to be 48 hours.
Yes.
It has to be correct.
If 12th you have filed, today is 14th. What is the date you have mentioned in the presentation form?
It was given 13th initially, but there the
13th cannot be.
It will infructuous. Kind of 2 months gracious, but his file is in the
Monday. May I be permitted to mention once?
They are coming. Difficulty is this. Is a compelling.
Matter is not in the list. How can it be taken out?
Even my lords, well, is a compelling circumstance. This is a fraud, my lord. Next day they move an ex parte.
Any caveat is there?
No caveat.
Supplementary করুন ওই স্বাতী
May I be
স্বাতীকে সময় করে
may I be item number 754 of the monthly list. The urgency is this this section 20
said yesterday.
section 24 application.
Why did not mention yesterday?
My junior has not brought the mentioning sleep. That's
Section 24.
section 20 40 kilometers up and down,
What is the
having a minor son,
Sir, what is the next date fixed in the
21st of August.
Nothing. Please mention on Monday. Before the
For correction. One for correction.
No, I could not follow. Yes.
For correction. For correction.
Correction, yes.
Leave to file without certified copy.
What is the urgency?
Urgency matter. This is the application for transfer under 227, my lord.
Transfer under 227.
MSC tribunal to another MSC tribunal. Subject
Yes.
correction under section 24, my lord, is not maintainable.
File it, it will appear. Yes.
Lord, with your lordship's leave, may I mention CO 634 of 2025 appearing in your lordship's monthly list as item number 1026.
What do you
Lordship
want?
has heard us. My lord,
What do you
notice was served. My lord, any day, I'm not
Why
immediately
did you
asking.
mention yesterday? Please come on next Wednesday.
Lord, kindly.
Permitted to
My
mention.
lord, I shall come next Wednesday.
In this matter, my lord, petition, my lord, plaintiff, my lord, moves an application.
What do you want?
My lord, this order was passed, my lord, by your lordships, my lord, staying the operation of the impugned order, my lord.
Yes.
My lord, though, my lord, in the lower court, my lord, without exhibit of the document, my lord, lower court, my lord, granted, my lord, the expert opinion, my lord, for handwriting.
What do you want? You are for the opposite party.
And for the opposite
What
party,
do you want?
my lord, he is a plaintiff, is a
Contested application is the rights difficult.
my lord, kindly, we are conceding, my lord. Whatever order your lordship will pass in future, my lord, kindly pass the same civil order. Because, my lord, plaintiff is 78 years of old.
You want the civil division application to be allowed?
Allowed, my lord.
To mention.
My lord, only, my lord, only.
Please notify the other side.
I have already given notice, my lord. Mention.
Please notify to be mentioned.
Monday.
Yes, Monday. Yes, call the next matter. Call the list.
এখানেই থাকবে।
Item number 1. লেখা আছে লিস্ট ফলো করুন জানো না তো স্টুডেন্ট
But appearing, yes, one thing happened. There is a typographical error for which the earlier order, which is available in the surveyor, there is some corrections. That is why it has. Ashun. It was pointed out that there is a
নাম্বার আছে তো, নাম আছে, পিটিশনারের নাম আছে, আবার দিতে হবে, দাও একটা স্লিপ দিন, দিয়ে দিচ্ছি।
Okay, same. Some corrections were there, so some corrected order be uploaded, same.
নাম কোনটা?
Because there were some typographical errors which were corrected, but the wrong order was uploaded. Yes. Yes.
Lordship appeared before one civil, in one civil divisional application between the same parties
It has
regarding
been
the
submitted by the learned advocates for the respective, it has been submitted. You are for the কোনটা? হ্যাঁ, যেটা আসবে সেটা কি আছে? আচ্ছা,
That is number 4.
সোমবার কি? তো 2954 উপর বলে এসছে। No, 2149. এটা কত নম্বর আইটেম? 4টা 2194. Oh, আসুন. It has been pointed out that the
Five.
কোনটা? তাহলে সাপ্লিমেন্টারি বার করতে হবে। হ্যাঁ, সার্ভার হবে না, তাহলে সাপ্লিমেন্টারি, তাহলে নট টুটা করে করো, তাহলে নট টুটা করে ঠিক আছে।
That is number 5.
My lord, Mr. HON'BLE is appearing for the petition.
Where is he? Two zero. What is this? না, এটা সব ভুল নাম্বার কি অ্যাপিয়ার করছে? Since I am not inclined to take up this matter on personal ground, this matter stands released from the list of this bench.
had called him regarding the instruction. He said, I am coming, but he just,
One time.
yeah, in time 15 days. Because in Hindu and number one, okay, 15 days time without kindly. I could not
So
take, he
Mondol-
was crying.
Certain thing I have,
পরে বলো,
Mondal, he wants time on this ground.
kindly record my statement.
Uh,
Oh, he wants to file affidavit, he said.
if he in opposition,
No, don't.
yes, ma'am. Well,
Then I'm
everything is forged document. On the basis of forged
then
document,
I'm
well,
I'm granting leave to
He
file
can-
affidavit, Mr. Bose. Then I'm not recording that fact.
মারা গেছে কাল থেকে তো বললো, আমাকে তো বললো। Yes,
Is it necessary, Mr.
no.
Bose? That is why I'm saying.
But kindly record, the client has instructed me to, because why I took adjournment. Kindly record.
No. I will
on the
say that
adjournment, I filed.
that he wants to file affidavit of opposition on his pair.
After 3 weeks.
On his pair, I
Yeah,
can.
3 weeks.
Yes.
2 weeks and 1 week you can
Yes.
can file a when this matter is called on for hearing.
My income tax return, I am doubting that his income tax return also forged. Each and every document base, which I am learned friend, every
Mr.
document
Bose,
is forged.
Mr. Bose, please take instructions. He's saying that your documents are also.
Yes, I am doubting, because my document shows my income tax return. He shows another thing.
I am told, my lord.
My lord, e-filing acknowledgement, my lord, number is also different. It cannot be. It cannot be.
Execution.
Should
Mr.
be
Bose,
proper,
when it is a
my lord,
serious
should
thing.
be, should be proper inquiry thereafter investigation. In this situation, each government document which are relying, my lord, everything has been forged by my learned friends' clients. Each and every court.
No, Mr. Mondal, you said that you have filed an application on this. So
My
that
lord,
application is pending.
they are pending.
Then I think this should be, if that is pending, you can thrash out there with regard to this fact.
Also, my lord, that forged document also relying before your lordship. Your lordships can.
I appreciate that, but it was part of the trial court's record because before two forums,
Can also preliminary inquiry whether, my lord, that income tax.
when
return-
that application is to come up.
Yes, my lord.
When,
Yes.
কবে আসবে দরখাস্ত
before the trial court, before the trial court.
কোর্টে দরখাস্ত 340 কবে আসবে শুনানির জন্য?
ডেট ফিক্সটা নিচু কোর্টে তুই তো জানিস এখন।
আমি তো জানি না, তুমি
বাবা তুই জানিস না, মানে 28 August
28th of August.
Yes.
তাহলে I think this should be posted after that. Or for the present, I make it out of list with liberty to mention.
My lord, I will file, my lord, opposition.
No,
Each-
you file your.
stated, my
No, no, that direction is there.
Yes.
So I think I directed after 3 weeks. Instead of that, I'm recording your submission that you have filed an application under 340.
Yes.
It is posted for hearing. That is why I'm directing.
Yes.
আচ্ছা এফিডেভিটের ওইটা থাকবে, তারপর কি বলছি লিস্ট দিস ম্যাটার আফটার 3 weeks বলেছি, ওইটাকে না করে ওইটাকে কেটে দিয়ে লিখুন মিস্টার মন্ডল ফার্দার সাবমিটস
Seven, I am appearing on behalf of the respondent, opposite party wife.
My lord, in item number 7, my lord, I beg to appear on behalf of the petitioner. My lord, I have prayed for a stay order till disposal of the CO in this case. And so far as the CO is concerned, or the matter is concerned, I draw my lord's attention to paragraph 6 of this application. Paragraph
So
6.
I'm fixing this matter and extending the.
My lord, kindly appreciates one thing. Interim order expired August 2024.
That is why they have applied for file an
My
application.
lord, not a single explanation advance as to why they
Then you file an opposition.
My lord, kindly.
Learned
My
advocate.
lord, please one moment. My lord, please find that I have annexed all the papers of compliance of all the orders.
But he wants to file an opposition because this interim order has long expired. So
Yes,
he's entitled to let him file an opposition.
My lord, I have prayed for a fresh order in this case,
Alright,
as
so
I am not a defaulter. I am not a defaulter.
All right,
Please find from my the annexures will show that I am not at all a defaulter.
Yes, let him file an opposition. This application is for extension of interim order. The prayer for extension of interim order is seriously opposed by the learned advocate for the opposite party. He prays for a liberty to file an opposition to such application. Fuster as paid for by the learned advocate for the opposite party. Let affidavit in opposition to Can 1 of 2025 be filed within a week from date. Reply thereto be filed within 3 days thereafter. Fuster list this matter after 2 weeks. Under the yes, next. Under the heading application. Under the heading application. Yes, next.
My lord, I am for the petitioners, my lord.
I'm appearing on behalf of opposite party number 1 and 2, my lord.
This is my application for reinstatement or fresh interim order, my lord. The interim order was passed on 9th July 2024 by Justice Vishwajit Basu. It was till the end of November, my lord. Due to illness of the petitioner number 2, who is the wife of the petitioner number 1.
What is the improved order?
The improved order is challenging, and wherein an application for amendment of written statement has been allowed.
Written statement has been allowed. Will file আসছে কেন সবকটা? You are the plaintiff.
I am the plaintiff.
Yes. What is the amendment sought for?
My lord, in the amendment is at page 36.
Yes.
We are trying
What is the suit for?
The suit is for declaration and permanent injunction, my lord.
Yes. Where is the plaint?
The plaint starts at
Page 16.
page 16, my lord. Yes, my lord.
Where is the application for amendment?
It is at page 36, my lord.
Page
36. They are trying to change the number of one deed, my lord. The defendants, they are trying to change a number of a deed, which deed is not there in the volume of the sub-register. And there is no explanation also why this amendment is being sought at the stage of trial. It's a one-page application. We had also taken out a written objection to this application.
Where is the written statement?
Written statement is at page 23. Starts at page 23. আমি একটা ফাইল করেছি যেটা প্রপোজ করছি সেটা আছে আমাদের কাছে কত
Yes, they are claiming title by virtue of this deed. They are claiming,
They are claiming-
defendants are claiming.
Yes,
Yes, what is the difficulty?
they had filed a earlier amendment application
Yes,
that was not pressed by them, my lord.
what is it the same fact they wanted to introduce? Where is the earlier application for amendment?
My lord, that we need to procure, my lord. We will get that.
Nothing. It's only the deed number. If they fail to prove that, they will.
My lord, kindly,
Yes.
kindly takes up my objection, my lord, once.
Yes. What is your objection?
Objection. Page 37, 38, 39.
Paragraph 6,
Paragraph 6.
page 38. Paragraph 6, page 38, my lord.
Yes, 38. Yes. Yes.
My lord,
Yes, paragraph 6, page 38, which portion?
my lord, 17/9/1959 তারিখে নিমতিতা এসআর অফিস রেজিস্ট্রিকৃত সাচানসাজ হেবাবিল এওয়াজ দলিলখানি সম্পর্কে ইতিপূর্বে জ্ঞাত ছিলেন না। পরবর্তীকালে উকিলবাবুর সহিত যোগাযোগ হেতু উক্ত বিষয়ে আলোচনান্তে বর্ণিত দলিলের জাবেদা নকল সংগ্রহের জন্য উকিলবাবু পরামর্শ প্রদান করিলে এই পক্ষ জ্ঞাত হইছেন যে ইংরাজি 1959 সালে এত নম্বর ভুক্ত কোনো দলিল রেজিস্ট্রি হয় নাই। 1959 সালে ফের দলিলটির নম্বর হইতেছে 5316। এই মতে বাদীপক্ষ যে দলিলের বর্ণনা প্রদান করিয়াছেন তা এক কথায় জাল এবং সৃজিত দলিল হইতেছে বলিয়া এই পক্ষ নিবেদন করেন। এই মতে বাদীপক্ষ
Which deed is forged according to you?
my lord 6582 of 1959
62 of 1959 is forged. And what is your statement with regard to 450T 02 of 1958?
my lord 1958 that জবাব সংশোধনের দরখাস্ত প্রদান করিয়া এত স্থলে এত নম্বর দলিল বলে প্রার্থনা করিয়াছেন। প্রকট পিটিশনে এত নম্বর দলিলের জাবেদা দখল প্রাপ্ত হয় নাই, প্রাপ্ত হইয়া দখল করিবেন মর্মে বর্ণনা করিয়াছেন। তদুপরি উক্ত দিনে 1 নম্বর
According to you, but
page 39 last portion,
page 39, yes.
last portion,
Yes.
তদুপরি উক্ত দিনে শোকজ পিটিশনে 3205 of 1959 নম্বর দলিলের জাবেদা দখল প্রাপ্ত হয় নাই, প্রাপ্ত হইলে দাখিল করিবেন বলিয়া মর্মে বর্ণনা করিয়াছেন। তদুপরি উক্ত দিনে 1 নম্বর 2 নম্বর বিবাদী পক্ষ পুনরায় জবাব সংশোধনের দরখাস্ত প্রদান করিয়া 6582 of 1959 এর স্থলে 4502 of 1958 নম্বর দলিল হইবে বলিয়া প্রার্থনা করিয়াছেন। 1 নম্বর 2 নম্বর বিবাদী তার তথাকথিত 4502 1958 নম্বর দলিলটি দৃশ্যত সার্টিফাইড ফটোকপি গত ইংরাজি এত তারিখে হুজুর আদালতে দাখিল করিয়াছেন। 1 নম্বর 2 নম্বর বিবাদী দাখিলি ইংরাজির 15/7/2023 তারিখে জবাব সংশোধনের দরখাস্ত এবং ইংরাজির 17/2/2024 তারিখে জবাব সংশোধনের দরখাস্ত কন্টেন্ট অলমোস্ট সমগোত্রীয় হইতেছে। 1 নম্বর 2 নম্বর বিবাদী পক্ষের বর্তমান কন্ডাক্ট আইনত ন্যায়ত কখনই গ্রহণযোগ্য নয় বলিয়া এই পক্ষ নিবেদন করেন। এই পক্ষ 5316 1959 and 3205 of 1959 দলিলে জাবেদা নকল হুজুর আদালতে দাখিল করিয়াছেন। তদৃষ্টে প্রমাণিত হইবে 1 নম্বর 2 নম্বর বিবাদী পক্ষের পূর্বে রিলায়েড ডকুমেন্ট অর্থাৎ 6582 1959 and 3205 1959 নম্বর দলিল দ্বয় যা হইতে 1 নম্বর 2 নম্বর বিবাদী পক্ষে রাইট টাইটেল ইন্টারেস্ট অর্জিত হইছে বলিয়া বর্ণনা করিয়াছেন তা জাল এবং সৃজিত হইয়াছে। তা বাদীপক্ষ প্রমাণ করিতে সমর্থ হইয়াছে।
Yes.
More, my lord,
So according to you, the earlier deed which was referred to according to you was finished. The earlier deed, that is 6258 or something, that is according to 6582 is forced. And you have proved that it is forced, there is no existence of that deed.
my lord. And not only that, my lord, same application they filed. And that was, my lord, I have taken in my written objection, same application they filed, not pressed by them. Only dragged the proceeding.
Yes.
My lord, Lordship, if your Lordship will kindly extend the interim order.
Yes,
for
yes,
for
what do you say?
My lord, I will satisfy your Lordship furthermore, my lord.
What do you say?
My lord, in this matter, there was a typographical error, my lord. And
Yes.
that is why, my lord, we sought for the amendment, my lord. And
Yes.
upon payment of cost, this application has been allowed, my lord. My lord, this was simply a typographical error, my lord.
Yes, at what stage? At what stage?
It was, my lord,
Comments, my lord, page 28.
Page 28.
Affidavit.
Affidavit fine.
File.
Only fine.
The affidavit file, thereafter they filed this.
Yes, any exhibits have been marked? No. No exhibits have been marked.
no, my lord.
Exhibits, there is no marking of
My
exhibits.
lord, that instruction not with me, my lord. But one thing, my lord, Lordship, kindly have a look into that. That is not the typographical mistake, my lord. That is not the type. If your Lordship kindly extend the interim order, and my lord, for what period?
Strategy, I have heard both of you on merits now, interim order extensions. So this matter is appearing under the heading extension of interim order, but the learned advocates of the respective parties were invited to advance their argument on the merits of the civil revision application. Accordingly, this court, accordingly, the learned advocates of the respective parties made their submissions on the merits of the civil revision application. First up, in view thereof, this civil revision application is taken up for final hearing with the consent of the learned advocates for the respective parties. This application under Article 227 of the Constitution of India is at the instance of the plaintiff and is directed against an order being number 44 dated April 10, 2024, passed by the Learned Civil Judge, Junior Division, Second Court, Jangipur District, Murshidabad in Tatu Suit number 133 of 2019. First up, by the order impugned, the application under Order 6, Rule 17 of the Code of Civil Procedure stood allowed. Just a paragraph. Mr. Chattopadhyay, learned advocate, appearing for the petitioner, submits that the opposite parties herein claim title in respect of the suit property by virtue of a deed dated deed being number 6582/1959. Full stop. The said deed is a forged and fraudulent one, and the petitioner was successful in proving that there is no existence of the deed bearing number 6582/1959, and thereafter the opposite parties sought to incorporate a new deed in place of the said deed. A new deed being number 4502 of /1958 in place of the earlier deed being number 6582/1959. First up, he submits that such an amendment would amount to withdrawal of admission made in the written statement.
and already filed a certified copy of that deed.
I've said they have proved that there is no existence of that deed. First paragraph. The learned advocate appearing for the opposite party submits that since there was a typographical error, Mr. Chattopadhyay further submits that the application for amendment was filed after the commencement of trial without giving any explanation as to why the application for amendment could not be filed prior to the commencement of trial. তারপরে লিখুন, the learned advocate appearing for the opposite party submits that the application for amendment of the written statement was filed as in order to correct a typographical error with regard to a number of the deed in the written state, with regard to the reference of a number of the deed in the written statement. Full stop. Paragraph. Heard the learned advocates for the respective parties. He further submits that such prayer for amendment was allowed with cost of rupees 3,000. First paragraph. Heard the learned advocates for the parties and peruse the materials placed. Full stop. Mr. Chattopadhyay, learned advocate appearing for the petitioner, submits that the application would contain that the proviso to Order 6, Rule 17 of the Code of Civil Procedure stands attracted to the case on hand, as the application under Order 6, Rule 17 was filed after the PW1 filed the affidavit in chief. Full stop. On a query of the it is not in dispute that though only the affidavit in chief was filed, but no documents were marked as exhibits. Full stop. Thus, this court is of the considered view that the trial of the instant suit is yet to commence, and the application for amendment of the written statement was filed prior to the commencement of trial. Thus, the proviso to Order 6, Rule 17 of the Code of Civil Procedure does not stand attracted to the case on hand. Full stop. After going through the proposed amendment, this court finds that the petitioner, that the opposite party sought to incorporate the deed number 4502/1958 in the 9th paragraph of the written statement at page 3 in the 7th line of that page, in place of the deed bearing number 6582/1959. Full stop. After going through the proposed amendment, it appears to this court that the opposite party sought to correct a typographical error in the number of the deed by way of amendment. First of paragraph. The Honorable Supreme Court in
judgment, you know, 11 Supreme Court judgment, page 41 onwards.
The Honorable Supreme Court in the case of where is the reference? Life Insurance Corporation versus Sanjeev Builders Private Limited, reported at 2024 2024-16 SCC হবে, ঠিক আছে, পেজ নাম্বারটা বলে দেবো, has called out the proposition of law for proposition of law to be followed called out the principles to be followed while allowing an application, while considering an application for amendment of plaint. First of the Honorable Supreme Court held that all amendments are to be allowed which are necessary for determining the real question in controversy, provided it does not cause injustice or prejudice to the other side. And the prayer for amendment is to be allowed in order to avoid multiplicity of proceedings. It was further held therein that in dealing with a prayer for amendment of pleadings, the court should avoid a hyper-technical approach and is ordinarily required to be liberal, especially when the opposite party can be compensated with cost. It was further held therein that an amendment may be justifiably allowed where it is intended to rectify the absence of material particulars in the pleadings. Full stop. Paragraph in the case on hand, as observed herein before, that the proposed amendment was sought for in order to correct the reference of a deed which is a material fact for the purpose of deciding the dispute, for the purpose of deciding the real controversies between the parties to the suit. That apart, the prayer for amendment was also allowed subject to payment of cost. Thus, the petitioner has been duly compensated for the delayed approach made by the opposite party while filing a delayed approach made by the opposite party praying for amendment of the written statement. For all the reasons as aforesaid, this court is not inclined to interfere with the order impugned. Accordingly, CO number such and such stands dismissed. There shall be however no order as sought. Accordingly, can one stands disposed of.
Likely to file
But file
Amended
amendment honored of sir.
to the
Replica, if you are entitled to apply under the provisions. It's not a matter of course, it's the other way around. Plain additional written statement.
I'm grateful.
gratefully.
Thank you.
God bless you.
Next.
Item number 9, my lord, I am for the opposite party, my lord.
Yes, who is for the petition? Yes. Yes.
My lord, I oppose the extension of interim order application.
Extension of interim order.
Yes, my lord. It has been the extension of interim order has already the interim order has been vacated on expired on December 2024.
December 2024.
Third.
Yes.
Stated the ground, my lord. Paragraph 4.
What is the name?
Christmas vacation of the Honorable Court, the above interim orders.
Right. What is the main matter?
Despite mentioning the matter could not
What
be
is the main matter, madam? What is the main matter? Please come to the main matter. Please come to the main matter.
My lord, I am appearing for the defendant.
Yes.
Incoming. My lord.
What is the impugned order?
Appearing for the defendant petitioner, my lord. The plaintiff filed a suit for declaration of his title and injunction. And by way of amendment, subsequently by way of amendment, recovery of possession and mandatory injunction, prayer for mandatory injunction was added. In connection with that suit, the plaintiff filed an application under Order 39, Rule 1 and 2, Redway section for an order of mandatory injunction. That application was rejected. Thereafter, the plaintiff preferred appeal. Appeal was allowed. My lord, challenging that order, I preferred this revisional application, my lord. My lord, the dispute regarding the position of the plaintiff, my lord.
Yes, yes.
The dispute regarding
Make your submission, yes.
plaintiff, my lord.
Yes.
According to the plaintiff, he was dispossessed during the pendency of the suit. He filed the suit on January 2nd, 2024. And thereafter, he was dispossessed. According to the defendant, he was in possession But before filing the suit, and he left the suit property, thereafter he taken that property, suit property. My lord, kindly see, now my lord, kindly see, finding of the court. Trial court finding, my lord. Finding of the court, my lord, page 55, my lord. Kindly see page 55. 55. 55, my lord, third paragraph.
Yes, order dated 10th of June 2024. Order dated 10th of June 2024.
My lord, trial court,
Yes, my lord.
10th of June. Yes, 10th of June. Yes, my lord.
What is the relation between you and the opposite party? What is the relation between you and the opposite?
He was my tenant.
He was your tenant.
Yes, my lord. Yes, yes, my lord. He left the suit property. My lord, I am coming.
Allow me to make my observations.
Oh.
Then it will be easier for you to make submissions. So initially he was your tenant. When that tenancy stood expired and when you took possession, show me a document.
There is an agreement. There was an agreement
Yes.
between the parties, but since he failed to comply the terms and conditions
Show
of
me the agreement.
agreement is not here, my lord. My lord, I am coming. My lord, I am coming. One thing, my lord, I am coming. The order.
Possession. You took possession from him.
I took
Where is the document?
property.
Madam, please hear me, madam. That's the problem. You are not allowing me to make my observations. Where is the document that you took possession? Show me.
My lord, it is not here, my lord. At the time of evidence, I will show.
What evidence?
Before the court.
Mandatory injunction. This was what you have to. Madam.
He has to establish that
all right,
he was in possession.
All right. Yes, you make your submission. Yes.
No, my lord, thank you.
You make your submission.
With me, my lord. But, this is mine. This document is not with me at present.
All right. Then make your submission. Yes.
My lord, now. My lord, paragraph 55. Page 55, my lord.
So you are pressing the trial court's judgment.
I'm coming. Trial court's judgment, thereafter appellate court. My lord.
So trial court judgment is not paginated, Ms. Sharma. That is the.
But it was paginated, my lord.
I have the certified copy. Please refer to which paragraph.
Page is not here. 4, my lord. Page 4, even though the plaintiff has claimed that he was in possession. My lord, may I read, my lord? The plaintiff has claimed that he was in possession of the suit property all along, that is, till 25/1/2024 on 25/1/2024. The defendants allegedly put one padlock in the shop and denied access to the plaintiff. In short, the status quo of possession has changed, but the plaintiff has failed to back up his contentions that he was indeed in possession of the suit property. No documents of relevant period are placed to back up the claims. No materials to show payment of rent through any means is placed. No clear picture regarding the actual status of possession at the time of filing its and its change allegedly after 25/1/2024 is placed by the plaintiff. My lord, he has to, in case of mandatory injunction, he has to prove, he has to establish that he was in possession at that relevant point of time when he was dispossessed. And it is specifically mentioned that there was no document. And in the appellate court judgment, it is not reversed in the appellate court judgment, page 3, my lord. That is, it is settled principles of law, last 6 lines, that a person cannot dispossess from any property without due process of law. And it is admitted by the respondent that the appellant was in possession in that suit property, and there are sufficient documents produced the appellant in respect of his tenancy right over the suit property, but still the respondent put padlock on the side. This is therefore a fit case calling for the restoration of possession. My lord, but it was not reversed in the appellate court. That finding was not reversed in the appellate. He has not produced, he could not establish that he was in possession at that relevant point of time when he was at that on that particular day when he was dispossessed. My lord, in the injunction, in the mandatory injunction, my lord.
How you came to possession? How you came to possession?
He left the suit property.
How you came to possession? In the suit property, how you came to possession? Initially, there was a tenant.
Yes.
How you came to possession? Please show me how you came to possession.
My lord, since he left the suit property, I took the possession. He left the suit property before filing the suit.
When? What is the date?
That is September.
Please show me from your pleading that on which date.
I've
Yes, show me.
I've said.
Show me. Which page? This prayer for mandatory injunction.
My lord, page 26. Page 26.
26.
Page 26, last তথায় 26 তথায় বাদীপক্ষ সম্মতি দেয় না যেখানে সেখানে স্ট্যাম্প লিখিতভাবে সিদ্ধান্ত স্থির হয় যে আগামী 2 বছরের জন্য তথা 2023 সালে 1 অক্টোবর হইতে 30 সেপ্টেম্বর 2025 মাসিকায়
Page 26, which portion you are placing?
last 1 2 3 5 6
Middle portion, my lord.
Middle portion.
লাস্ট 11
সেখানে স্ট্যাম্প লিখিতভাবে সিদ্ধান্ত হয় যে আগামী 2 বছরের জন্য তথা
দোকানের ভাড়া দিতে হইবে তথা
বাদীগণ সম্মতি দেয় চুক্তিপত্র সই হয়। Then when you took possession?
তথায় বাদীগণ সম্মতি দেয় উহাদের আশা সাক্ষী চুক্তিপত্র সই হয় বাদীপক্ষ আরো স্বীকার করে যে চুক্তি অনুযায়ী শর্ত না মানিলে আমরা দোকান ছাড়িয়া দিব একথা বলে উপরে বর্ণিত চুক্তি সব পত্র সবটাই লিখিত এবং বাদী এবং বিবাদী উভয় পক্ষে সই স্বাক্ষরিত হইয়াছে চুক্তিপত্রের শর্ত না মানিয়া বাদীপক্ষ দোকানঘর মালিক বিবাদী পক্ষের অনুকূলে ছাড়িয়া দিলে স্টেটেড দিলে বাদীপক্ষ দোকানঘর নিজ অনুকূলে লইয়াছে I am stated.
When?
What
is the date? What is the date, madam?
Date also has given.
Yes, tell me which date.
Date given, my lord.
No, this prayer for mandatory injunction was incorporated by way of amendment.
By way of amendment.
Yes, my lord.
So initially there was a initially after filing of the suit there was any ad interim injunction.
No, my lord. Because 2nd January it was filed and 24th January he was dismissed according to
What happened is that the suit was instituted.
Please, sir, I will come to you. 2nd January of which year?
24.
24.
2nd January 24.
Suit filed.
24th January 2024.
24 or 2nd January?
2nd January suit filed.
Yes.
24th January, according to him, he was dispossessed.
Yes. 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 Anything more? Yes.
Yes, ma'am. The plaintiff is the tenant for last 45 years, madam. Now, what happened is that the primary agreement, a verbal agreement was made between the predecessors of the petitioner, defendant, and the plaintiff, madam. Now, the defendants got the property gifted from their grandfather. Now, the petitioner, the plaintiff herein, is staying there since last 45 years. Now, what happened is that in September 2023, the petitioner came and padlocked the property. We approached the police station. The police came and they opened the padlock. And they made an agreement where they stated that from September 2023 to October 2026, that 1,500 rupees will be paid. This agreement was made and they started staying there. Now, they started creating commotion and the suit was filed on 2nd January
From 2023 to 2025, not 2026.
Yes, my lord. I stand correct.
Yes.
2025. Now, my lord, they started creating commotion on January 2nd, 2024. The suit was filed for declaration and permanent injunction. thereafter, when they received the notice from the court, they immediately went there with people and they padlocked the entire property. We subsequently approached the court and stated that we need to amend the plaint because the subsequent facts has to be incorporated.
Yes.
The trial court, based upon
Where is the order of ad interim injunction?
my lord, the order of
Ad interim injunction.
yes, my lord.
Because
my lord,
ad
it is
interim was not.
no, my lord. The thing is, my lord, may I speak?
Yes, where is that order? Have you annexed that?
No, my lord, that order is not annexed to you.
Do you have a copy of that order?
No, my lord, at this instance, I don't have.
Yes.
My lord, after that, the trial court allowed that amendment based on that fact. Now, the Order 39, Rule 1 and 2, we have filed in February with the new prayer that the mandatory injunction in the temporary form may be granted. Upon hearing it, the trial court stated that no mandatory injunction has means to be granted, and we filed an appeal, and it was affirmed that means it was allowed. The mandatory injunction was allowed. Now, my lord, the primary thing is that the trial court states, my lord, it is at page 52, my lord.
Page
52.
Yes.
My lord, this is the order of the trial court, June 10th, 2024.
Yes.
It states that the plaintiff, my lord, fourth paragraph from the
yes, yes.
The plaintiff has alleged that the defendant has put a padlock in his shop and is denying him access. In view of changed circumstances, my lord, the plaintiff wants to incorporate the aforesaid fact and also amend the praying portion. After considering the materials in hand and submissions of the learned advocate, I am of the opinion that the amendment sought will not change the nature and character of the suit. Further, the amendment will aid this court to determine the real issues between the parties. In addition, the defendant will get ample opportunity to rebut the claims made, my lord. So, after this, the amendment was made. Now, my lord, in the findings of the at page 53, my lord, the court also acknowledges that the learned advocate for the plaintiff submits that after receiving the notice from this court, the defendant on 25th 1, 2024, it is after the institution of the suit, forcefully padlocked on the shop. She prays for passing of mandatory injunction, which was later not allowed, and in the appeal it was allowed. My lord, now in the impugned order, which they have challenged, my lord, page 2, my lord, inner page 2.
Yes.
Paragraph 3.
Yes.
My lord, may I read? At the time of hearing, the learned advocate appeared on behalf of the appellant, submitted that it is admitted by the respondent that the appellant is the tenant under the respondents, and he was in possession of the suit property, but during that period, a dispute cropped up between them, and thereafter the respondents put a padlock in the suit property. As such, suit property can be restored by way of passing an order of mandatory injunction. In support of his submission, he stated a judgment. Now, my lord, paragraph 5, third line. It appears, my lord.
Yes.
It appears that the plaintiff was a tenant in respect of the suit property, and when a dispute cropped up between the appellant and the defendant, title suit number 2 of 2024 was filed. When the appellant was in possession, my lord, was filed before the court, and during pendency of the title suit, the respondent put a padlock on the shop room. A title suit, my lord. In the next page, it is written, my lord, such a relief, it is, my lord, it's illegible in my copy, my lord. It is indeed true that such a relief should be granted only in exceptional cases, though exercise of such a discretion should be limited to rare and exceptional cases. Till at the same time, no court should think that in law there is an absolute bar to the court granting such relief. Now, my lord, in the middle portion, the court states that I find that the appellant was a tenant in respect of the suit property, and he has filed this title suit at the initial stage for a declaration and permanent injunction. And during pendency of the suit, the respondent puts padlock on the suit property. Well, my lord, the another thing I would like to place, my lord, that in the order 9, Order 39 Rule 1 and 2 application, in which we have prayed for the mandatory injunction, the list of documents which we have produced before the court, there, my lord, the rent receipts, the electricity bill, my lord, it is at
Yes.
if your lordship kindly comes to page 39, my lord. There is the last portion of the Order 39 Rule 1 and 2 application, my lord. My lord, we have produced the rent bills.
Yes.
My lord, we have produced the rent bills.
Have you brought the decision of AIR 85 Calcutta 248?
My lord,
Last rent was paid in the month of Bhadra 2020.
my lord, after that, we have tried to pay, my lord, they have not.
Have you brought the decision of AIR 85
No,
India
at-
bills?
At this time, my lord, I am not equipped.
You have not brought.
My lord, at this time, my lord, I am not. I apologize.
My lord,
My lord, in page 40, my lord, we have produced the agreement also and the written complaint, as well as my lord, the general diary we have made, like. The agreement is there, my lord. It is not annexed here. The agreement of from September 23 to October 2025, it is annexed there, my lord. My lord, their contention is that from September 23, we are not staying there. But on September 23, we have made the agreement and we have been staying there.
Yes, anything? Ashwin, this application under Article 227 of the Constitution of India is at the instance of
My lord, another thing, if I, my lord, simply, the other thing is that when the interim order was expired, at that instance, we had approached the court for police help to remove the padlock from there. The court has ordered that the padlock can be removed and has ordered for police help as well. My lord, we have approached the police, but till date, they have not helped us. We have again approached the court, but the court says that
all
order
right,
will.
so this has come up under the heading extension.
Yes, my lord.
You have filed an application.
Yes,
yes, my lord.
Yes.
my lord, with
Can
my lord, with
That one.
regard to the extension of interim order,
yes.
may I please state a thing, my lord? In the extension of interim order application at paragraph 4, my lord, may I state?
Where is the application for? Page.
My lord, at page 3, my lord. In
Yes.
paragraph 4, it is stated that during the Christmas vacation, the honorable court, the above.
All right. This matter is appearing under the heading
We, and
Yes.
Petitioner, Lordship. I am for the petitioner.
But I'm appearing with the opposite party.
This
Yes.
is my affidavit service, Your Lordship.
Yes. What is the impugned order?
Lordship, impugned order was, Your Lordship, will kindly come to page.
What is the impugned order?
Impugned order, Lordship, I had filed an application for DNA test, Your Lordship, under sections 120, 112 and 114.
What is the suit for?
Exactly, Lordship.
What is the suit for?
Suit is, Lordship, they had filed for partition, Your Lordship, claiming to be the, Lordship will kindly come to page 3 of my petition, Your Lordship. This is a family tree, Your Lordship. Paragraph 2.
All right, Mr. Subhadran, I'm extending, I'm fixing this. Ashun.
eleven, 12, 13 are same.
11,
12, 13. But what happened, my lord, and we have filed 4 applications.
Yes, for what?
The same civil divisions.
No, what is the impugned order?
But I'm coming to that, my lord. But there are 4 civil divisional applications. Kindly hear together, my lord. 3 has been listed before, your lordship. 1 has not been, my lord.
Same order will be passed in the other, no problem. Please move this.
No, my lord, before that, my lord, I have some difficulty also, my lord.
What difficulty?
My lord, the memorandum appeal and all these things I have not received.
What is the order which is under challenge?
My lord, I will be placing on any next day, my lord. Kindly, my lord.
The next date will not come, Mr. Samanto.
My lord,
Next day, nobody knows when it will come.
that I know, my lord, it will
That
go
is
down.
this place. Please make your submissions.
My lord, I have not seen the memorandum appeal even. My lord. This
Why?
is
How could you file this civil division application?
that is the difficulty, but that is difficulty on my part.
Mr. Samanto, please move.
My
Please
lord,
move.
kindly give me 1 day time, my lord. 1 day time, my lord.
Then I can adjourn you. No difficulty, but it will
For the interest
on
of
the on the prayer of the learned advocate for the petitioner, the civil division application stands adjourned. 11, 12, 13 order next.
11, 12, 13 are same, my lord.
11, 12, 13 same order. Yes, call the next matter. 14. Yes. Yes.
My lord, order,
Mr. Banerjee.
order 9, rule 13, my lord, allowed. My lord, one,
You have challenged.
one word averment, bater betha. And my lord, kindly see
One word averment.
bater betha. Bater betha. That is the averment. That is one word averment. And my lord, kindly sees, my lord, the observation of my lord.
I will remember this when you come for the other side.
Lord, pleadings should not, my lord. These are the pleadings I would advise, my lord, not to come.
Allowed. Supreme Court saying that when
Kindly, my lord, sees, my lord, once, my lord, the
when
impugned order.
section 5 and this order 9 rule 13 discretion exercise.
Well, the learned trial court comes to a finding that the medical certificate is fraud. Kindly takes up that. The learned trial court comes to a finding that the medical certificate is fraud. Kindly,
Even after that, the Honorable Supreme Court has set aside the division being judgment on fraud. Even after that.
Well, kindly takes up the amendment was and then after that, whatever your lordship feels right, my lord.
All right, then I can do one thing. I am staying your suit. All further proceed. You are the plaintiff. Let it remain.
Well, suit has been decreed already, my lord.
Yes, now it's
Execution.
everything will be stayed.
Execution
Execution and
yet to be
other
filed.
things has to be stayed then.
But well, kindly consider this.
I'm staying. I am admitting this.
Well, this needs to be addressed. Well, this point. Well, I communicated this. The specific instruction was I communicated this aspect.
Yes,
Whatever
yes. Move your
falling from your
application.
lordship, my lord.
Move your application.
Well, whatever is falling from your lordship, my lord, I communicated this to my counterpart, my lord.
All right, please move your
Instruction was to
application.
move, my lord.
Please move your application. What do you have?
My lord, page number 33 is the application.
Yes.
Paragraph number. It's a one paragraph application, my lord.
Yes. What is the suit for?
Section 8 of West Bengal Land Reforms Act, my lord.
Preemption.
I'm the preemptor.
You are the preemptor.
Preemptor.
Don't have those points of the larger bench. None of the points are here.
Well, those are not, my lord, involved here.
None
Co-share on the ground of co-share, my lord.
entire share is not involved.
No, no.
Vastu also not involved.
No, all those points.
Short consideration also not involved.
No. Specific findings, my lord, that everything is in form.
Yes. Section 5, yes.
Well, this is, my lord, Order 9, Rule 13 application, my lord, first paragraph.
Page 33.
33.
Yes.
Well, fifth line from the top.
Yes.
গত ইংরেজি 13/7/17 তারিখ হইতে 12/12/18 তারিখ পর্যন্ত বাতের ব্যথা। This is one of the aberrament. This is not the only aberrament.
This is a serious ailment, Mr. Banerjee. Only those persons who suffer from this ailment knows. I think you have not seen anyone suffering from that.
43-year-old man. 43-year-old man says this.
Cannot suffer from arthritis. You have the medical documents with regard to that 43-year person do not suffer from arthritis.
No, my lord, I'm not saying that, my lord. My lord, cannot kindly, my lord, takes up the impugned order one line after that, my lord. Page number 3 of the impugned order, my lord.
Page number 3 of the impugned order. Yes. Yes.
The last paragraph. There was a delay also, my lord, 88 days. I'm not, my lord, pressing that.
Yes.
The doctor who gave the medical certificate is no more. Therefore, his son identified his signature.
Because you are not challenging.
88 days delay, my lord. My lord, I'm challenging, my lord. Same aberrament has been made in the Section 5 application as well, my lord. One.
So you are not challenging, Mr. Banerjee.
I've challenged the entire order, my lord. The entire order.
You are not pressing your challenge with regard to Section 5.
Condones the delay as well as, my lord, allows the order 9 Rule 13.
Pressing your challenge as against the condonation of delay.
No, my lord. Technically, I have, my lord. The revisional application, I have challenged, my lord, the entire order, my lord.
Yes.
Well, it kindly sees, my lord, nothing useful could be elicited from the medical records and the entire case record, which would indicate that the petitioner was fit or medical certificate was obtained fraudulently. After that, my lord goes on to allow nothing else, my lord, and upon payment of, my lord, 3,000 cost.
When the ex parte degree was passed?
Yes. Well, decree was passed on 19th of September 2018.
19th of September.
And my lord, the matter was ordered to be ex parte on.
So it is a case of non-service of summons, no?
No, they appeared thereafter.
Thereafter disappeared.
Thereafter disappeared.
Ashun, this application under Article 227 of the Constitution of India coming after 5 minutes.
Petitioner Lordship.
Yes.
My lord, husband is the petitioner before Lordship, my lord, in a suit for
Alimony.
yes, my lord. Initially, Section 24 was filed by the wife. Now, my lord, what happened?
Hindu Marriage Act.
Yes, Hindu Marriage Act. My lord, I also claimed for maintenance. I have also made claim. My lord,
Also made claim means
my lord, the husband. Now, my lord, that is not the concern. My lord, I just take your Lordship to the my lord. After post filing of my lord, Section 24, my lord, the affidavit of assets following Rajnish versus Neha was filed. My lord, both parties filed. Now, my lord, initially, the wife, my lord, filed an affidavit stating that she has no independent income of her own. That was the affidavit. Then, my lord, we filed an application under Order 11, Rule 5 for disclosure of some documents, which I pointed out that she is having her own independent income. She has suppressed that, and my lord, she has independent income of her own in Punjab National Bank. Now, my lord, that application was allowed.
independent income in Punjab National Bank.
Account. Having account in Punjab National Bank. She is a professional singer. She is a member of Milord Indian Milord Singing Association, and she performs Milord regularly. Stage performance, public performance, she done. Now, Milord, what happened, Milord? Thereafter, Milord, the learned court below was pleased to allow the application, Milord, directing her to disclose the account. That account ultimately disclosed, and Milord, huge Milord income, Milord, is appearing. Milord, as a result of that, Milord, I, Milord, filed an application under Section 340. Now it is, Milord, 215 read 379 of the BNSS. Milord, I filed an application, Milord, for taking cognizance for, Milord, giving, Milord, false affidavit on oath. Now, Milord, that application has been turned down by the learned court below. Lordship kindly sees the order in tune for a moment. 20th June 2025.
Mr. Chakraborty, rejection of 340 CRPC or the new provision is a civil revision maintainable
Yes, Milord, revision is maintainable.
before the single bench or
Before
before
the before the single bench. Why, Milord? I'll just show it to your Lordship, Milord, the provision for once. If your Lordship kindly look into, Milord, the BNSS provision. Now, Milord, same perimeter provision, Milord.
ENSS টা আছে?
Lordship kindly takes my book, Milord.
No, no. Oh. না না এটা এভিডেন্স
Sees, Milord, what is the recourse available, Milord, to the concerned judge? Milord, he may either, Milord, make a preliminary finding.
379.
379. Milord, he will, Milord, either, Milord, make a preliminary finding, or, Milord, take cognizance of the offense happen, or, Milord, transmit it to the concerned jurisdictional magistrate's court. Milord, these are the three options available. And, Milord, thereafter, Milord, action of the witness and his appearance to be secured. Now, Milord, Lordship kindly sees.
Mr. Chakraborty, there is a provision of appeal against not taking any steps under 380.
Yes, now, Milord.
So,
Milord, the
refusal also to take steps. So, rejection is refusal to.
Milord, I'll come to that. Milord, Lordship kindly see.
And it's a court. Appeal lies to the court, which the former is subordinate within the meaning of subsection 4 of section 215. What is that court? It must be a criminal court.
No, Milord, I'll come to that. Lordship kindly sees for a moment, Milord. I'll just show, Milord. Lordship kindly see the relevant paragraph of Rajnish versus Neha. Milord, page 370. Milord, 72.8 is the paragraph. Lordship kindly sees for once.
Yes. No. I'm not disputing that.
Now,
The
Milord.
court, according to you, the court can consider the initiation of proceedings under 340. But 340 is new. 379.
Milord,
379 2.
yes. Milord, is perimeter provision. Lord,
Yes, yes,
says. Milord, if it is Milord 340 also, Milord, same provision. Milord, the appellate, Milord,
the appeal, where does the appeal lie? If the appeal lies before a criminal court, because what is 215(4)?
my lord,
Court within 215(4).
215(4), Milord, states about Milord the offences in respect of which Milord court should take cognizance of.
No, it says court to which prosecution no court shall take a appeal to the court to which such former court is subordinate within the meaning of subsection 4 of 215. For the purpose of clause B of such a court shall be deemed to be a subordinate court to the court to which appeals ordinarily rise from the appealable decrees or sentences of such former court, or in the case of a civil court from whose decree no appeal lies to the principal court having jurisdiction. So if there is a provision of appeal for this, can you maintain a 227?
Milord, I'll just satisfy. Milord, Lordship kindly sees Milord the language of appeal. Milord, I'll just come. Milord, the perimeter provision of 380, here it is 341. Lordship kindly sees
Yes.
any person on whose application any court other than a high court has refused to make a complaint under subsection 1 or subsection 2 of section 340.
Yes.
It is not same provision of 379.
Yes. Yes.
Or against whom such complaint has been made by such court.
Either way, refusal or if it is accepted, both ways you can appellate matter.
Milord, I'll just take your lordship. Lordship kindly comes to that.
Yes.
379 is Milord same of 340. Milord, it says, when upon application made to it in this behalf or otherwise, any court is of the opinion that it is expedient in the interest of justice that an inquiry should be made into any offence referred to in clause B of subsection 1.
So that has not been done.
Now, Milord,
so the inquiry has refused to do so.
No, Milord, the refusal, Milord, subject to correction, Milord, refusal comes later. First of all, Milord, court has to make an inquiry.
Yes.
Court has to do. Here, Milord, the preliminary inquiry also not done. Lordship kindly see, thereafter, Milord, it comes, if the court forms an opinion as to, Milord, refusal to make a complaint. Milord, the refusal or Milord, the acceptance to make a complaint comes later. Milord, the preliminary inquiry has to be done. Here, Milord, the preliminary inquiry will not done.
Mr. Chakraborty, that amounts, ultimately that amounts to refusal to make a complaint. Complaint, if a complaint is made, has to be by a preliminary inquiry. If the court finds on the basis of the complaint, no, it's even what? Holding a preliminary inquiry and rejects. So it's refusal to make a complaint.
I bow down.
So refusal to make a complaint.
It culminates into Milord, Milord refusal or acceptance of Milord complaint. But Lordship kindly see whether the learned judge in the court below has committed jurisdictional error. Milord not Milord doing Milord the Milord Lordship kindly sees Milord 1.
If there is a provision of appeal to
appeal, Milord supporting this will be even if challenging this order. Milord, the purpose, Milord, will be subserved because Lordship kindly sees, Milord, this, Milord, section 24, Milord, the learned judge in the court is proceeding with. He is proceeding with section 24. Now, Milord, the ad interim order will come into.
Mr. Chakraborty, you can also pray for stay there.
Milord, court has.
Mr. Chakraborty, I cannot touch the main proceedings here. It's only 3.
Milord, then Milord, another problem comes. Milord,
you can't touch because
a criminal court cannot Milord stay a civil court's proceeding.
Why criminal court?
Because
what
Milord, it has
civil court? Please see the language of 215(4). It's not criminal. Maybe the section may be different there.
No, Milord,
you can take here.
It is Milord, I have got Milord the businesses, Milord. In this section, court has the same meaning as in section 215.
Yes.
215(4).
Yes. Kindly come to 215(4). Civil court is there.
My lord.
It's not the criminal court. You take the second link, or in the case of a civil court. from whose decree no appeal ordinarily lies.
Milord, your lordship is taking, Milord,
215 4. Yes. You skip the first portion for the purpose, or you can place the entirety. Otherwise, it's not matching.
Milord, I'll just. Yes, Milord, I was just searching, Milord, for Roman 2. For the purposes of clause B
Yes.
of subsection 1, Milord, clause B of subsection 1 is, Milord, any offense punishable under any of the following sections of BNS, namely so and so, so and so. Yes, it comes within the
Yes.
parameter of 236 and 237.
Yes.
Now, Milord, lordship, kindly see subsection 4. A court shall be deemed to be a subordinate to the court to which appeals ordinarily lie from the appellable decrees or sentences of such former court.
Yes. So
In the case of
appellable
a
decrees. Appellable decrees.
yes, Milord, here to
Sentences, both.
yes,
Or in the case of a civil court, from whose decree no appeal ordinarily lies to the civil principal court.
Milord,
So if
Milord,
you
my humble
case
submission,
no appeal lies also to the district
Milord,
judge.
probably, Milord, if I am not wrong, Milord, probably subject to your lordship what says, Milord. Milord, in this type of cases, Milord, which will, Milord, culminate into a conviction and sentence. Milord, civil court has no jurisdiction in Milord, appellate forum. Because, Milord, if lordship kindly sees the conviction and sentence part also, Milord, of this 215 and 379.
No, it says civil decree.
Milord, it will culminate into an offense.
Then you have to challenge the statute itself, Mr. Chakraborty. Statute says, gives you a right and fixes the forum. Statute gives you,
But
cannot say no here.
Even if, Milord, assuming, Milord, the civil judge, Milord, here, Milord, order has been passed by, Milord, the additional district judge. So,
Yes.
Milord, additional district judge in that suit. Milord, supposing
Live will be before the division bench then. That is why I'm saying there is a decision also.
Milord, before
on
this honorable court.
Yes. And I think if I am not wrong, Mr. Rai may be aware, there is a decision of this, it's before the division bench, and I think if I'm not wrong, exclusive determination is also being given to a particular judge. It's not that before every division bench you can move.
Milord, may I check and come back, Milord, tomorrow? Milord, Monday. Milord, I'll just check, Milord.
I think you please also check up the determination. I think 340 appeals, there is some determination given to some bench. So you have to move that bench only.
My lord, I'll just come back, Milord, on Monday. Lordship kindly keeps it on Monday. Milord. In that case, Milord, I'll take liberty to, Milord, approach the appropriate forum.
Yes, we are, because it's an.
Milord, the problem lies the same. Milord, even if, Milord, the honorable division bench takes cognizance of, it doesn't have, Milord.
Why are you not fighting on the matter? Since you are also claiming this is a roundabout way, it will only.
Milord, this is a false affidavit, Milord, filed on oath.
Mr. Chakraborty, you can take advantage of that in that proceedings.
Milord, the cross it will mean huge maintenance will be charged.
Your suit is also by you.
Yes.
It will also get delayed. Everything will get delayed.
Milord, I initially filed before the Bangalore High Court, Bangalore Court. Then, Milord, it was transferred, Milord, you section 25 petition here.
Mr. Chakraborty, it is you who is only delaying. With this matrimonial, then offshoot of the matrimonial, then appeal,
then it the provision of 11. If listen,
you can take advantage of that provision. Not complied with. What is the effect of that? All those provisions are there. And this is one thing. There is also a decision we will get in civil proceedings if a false deposition is being made, which is proved. That also 340 does not lie.
Milord, following Rajni versus Neha, Milord,
that is,
it has settled, Milord.
It does not say so. May approach.
72.8 is may approach.
Yes, does not say yes, it's maintainable. But there is a decision saying in such a case, because in every case, Mr. Chakraborty, there will be 340. You give evidence, other side gives evidence, court arrives at a finding. Then your evidence, you could not prove that it was a false evidence. Every case, that's the reasoning.
Milord, it is a question of, Milord, public justice is thought or not, Milord. This is, Milord, the section starts with public justice.
Yes.
Milord, then everybody will lose faith. Milord, it will set an example
that's the reasoning I'm telling you. Why it was held in civil matters between private parties, 340. This is not then in all cases. All cases it will be 340. After trial, you will file a 340 saying, look, this is the evidence in all cases. In a suit, you are saying, yes, I was forcibly dispossessed.
My lord, my humble submission, my lord,
After that,
purpose of filing affidavit, my lord,
finds
in
that
an
that statement of yours deposition was false. Then 340 also. So false statement on oath. In the witness box you are depositing. Also 340 will be attracted. All matters 340 will be attracted, sir. Once you fail to prove, all matters.
my lord, may I come back, my lord? I'll just
Also consult that decision. That reference I cannot give. But I have seen and I have referred to that also. I have succeeded while I was on that side.
I'll check.
So that's the decision. I've forgotten what.
Your lordship passed recently, my lord.
I have not passed. I've said I succeeded while I was on that side. I took that point.
Let a maintenance matter.
Yes, I think that's of Justice Barin Ghosh, and I've referred to that before Justice Gupta, Justice Girish Chandra Gupta.
Girish Chandra Gupta.
That is also not reported, but Justice Barin Ghosh's judgment is reported. Do you have the reference?
What was made in the plate?
Also, that dealt with that evidence, what will happen, and that's the that was the finding. Then in all civil cases, so both parties lead their respective evidences. Court may accept one or the other.
My lord.
Then says yes, if this is accepted, in all civil matters, yes, 340 in all matters.
But my lord, they
failed to, because that's the finding. You failed to prove that you are dispossessed. You failed to prove, or the other side
normal proceeding, my lord, I understand, my lord. This is, my lord, this should be. But my lord, the
in all
Rajini's basic purpose of Rajini's versus Nia, my lord, is to, my lord, put an embargo that you cannot depose on because it's a personal knowledge. You know, the evidence is otherwise.
Chakraborty, it can apply in all. Why all?
If somebody, my lord, does not disclose the personal, my lord, knowledge, my lord, your lordship knows, my lord.
All right, consider that doing all those decisions in the next day.
Well, lordship kindly keeps it on Monday, my lord. Subject to your lordship.
I am for the petition.
Yes.
Release the matter.
Release the matter. Why?
Yes. Petitioner filed a title suit.
Why releasing?
Only your father is appearing.
Father is appearing. What are you saying? Suit of
2001. 2002, my lord. Petitioner digged in favor of the petitioner. Thereafter, my lord, defendant.
Since I'm not inclined to take up this matter on for the next matter.
Number 17.
Lordship, I on behalf of the petitioner.
Yes, you are for the petitioner. What do you want?
Lordship, this is suit for partition. Preliminary decree passed on 12 August 2018. And
What do you want?
I want, Lordship. I filed an application for construction of the said my suit premises on 15 December 2000.
What do you want, sir?
Speedy disposal of the.
Say so. This application under Article 227 of the Constitution
and the defendant in a suit for declaration, not in the connection.
Yes, can I take up this matter?
Mr. Chakraborty is there.
Let the papers be placed before the Honorable Chief Justice for necessary orders. Yes, call the next matter.
Oh, তুই পাশে? হ্যাঁ। It is an appellable order. I'm not on
What is the nature of the order?
State Constitutional Forum. State Constitutional Forum, my lord, need not to go into this. Degree passed against me, 38 lakhs and odd. I'm ready and willing to pay.
What can I do, Mr.
My lord, I'll serve because once I go in the other forum, I have to deposit that amount. 50%. My lord knows. That is why I want to meet up the dues. A widow is the petitioner before lordship, though is now he is the proprietor, but this is a widow. 38 lakhs and odd is the
I will
principal.
record your submission.
Yes, certainly. My lord, can I record that within a week? I'll pay the 38 lakhs and odd, and the interest portion, my lord will decide. The 10% is directed. That is why. Otherwise, I'll not.
Yes, next.
It is humble prayer for expeditious disposal of the
what?
miss case along with the title appeal.
Miscase along with the title appeal. What is
Yes,
the
my
miscase for?
My lord, it is for restoration, my lord.
Then how can the title appeal be directed?
Will only the miscase to be heard expeditiously.
What happened? The appeal was dismissed for default.
My lord.
And you are paying for expeditious hearing.
My lord,
You are responsible for dismissal of the appeal.
yes, my lord. At the time of my lord, in fourth para, I have given the clause
Application under Article
Because, my lord,
under Article
as
Act 21.
I'm grateful, ma'am.
Thank you.
In item number 21, I am for the petitioner, my lord.
Yes.
My lord, this is an application for expeditious disposal, my lord. My lord, of suit 7 of 2016, my lord. It's a suit for eviction and, my lord, recovery of khas possession. My lord, there is an already earlier an order by the honorable court, my lord, to dispose of the application within a period of 6 months. My lord, that is page 17, my lord.
What application was directed to be disposed of?
My lord, 3 application was pending, my lord. 171 under, my lord, West Bengal Premises and Tenancy Act, my lord, and 72, and, my lord, an application, my lord, for amendment of plaint. Now, my lord, amendment of plaint was heard and it was disposed of, but the 2 application was not disposed of, and the main suit was not heard till the date. In compliance with the, my lord, order of, my lord.
17 has been disposed of. When it was disposed of?
My lord, it was heard, my lord, kindly see. My lord, the order dated, my lord, 19/7/2024. Amendment was allowed.
19/7.
2024.
No, please kindly come to the order dated 25th of June 2025. Order 6 Rule 17 was fixed on 12th of August 2025.
My lord, the amendment was allowed.
No. Please see Order 6 Rule 17. That is amendment, sir. That is 12th of August. It has been fixed. Order dated 25th of June 2025.
Yes, my lord.
So it is
My lord, so my lord, all the application is pending. That is my mistake, my lord. I apologize, my lord.
This application under Article 227 of the Constitution of India is at the instance of the plaintiff praying for a direction upon the learned civil judge, Junior Division, Second Court at Barakpur, to dispose of the pending applications in the said pending application in ejectment suit number 7 of 2016 expeditiously. First of the learned advocate appealing for the petitioner submits that applications under section 7 within bracket 1 and section 7 within bracket 2 of the West Bengal Premises Tenancy Act 1997 and an application under order 6 rule 17 of the Code of Civil Procedure are pending. Full stop. He further submits that a coordinate bench by an order dated 29th of January 2024 in CO number 80 of 2024 directed the learned trial judge to dispose of the applications expeditiously. Full stop. In view of the order sought out next.
My lord, within a period of 6 months, it was directed earlier, my lord. Within a period of 6 months. 3 applications.
In light of the submissions made by the learned advocate for the petitioner, CO number such and such stands disposed of by requesting the learned civil judge, Junior Division, Second Court at Barakpur to make an endeavor to dispose of the pending applications as expeditiously as possible without granting any unnecessary adjournments to either of the parties, keeping in mind the directions contained in the order dated 29th of January 2024 passed by a coordinate bench in CO 80 of 2024.
Grateful.
Yes.
Grateful.
Item number 22.
Yes.
Lord, in this matter, plaintiff filed the suit for declaration injunction. And thereafter, injunction was allowed, interim order was passed, restraining the defendant to interfere the possession of the plaintiff. Actually, what happened, the plaintiff purchased the property in the year 2003, the agricultural land, my lord. Thereafter, in 2015, defendants purchased the property, some other property, this contiguous land, and started interfering. And because of the reason, the plaintiff had to come before the trial court, learned trial court, praying for injunction not to interfere. And it was granted, interim order. Therefore, after finally the interim order has been made absolute in the form of status quo. But still then, the defendants are interfering and encroaching the property. Practically, there is no demarcation in between the agricultural two lands. There are no demarcation. Interfering, getting the crops from my land. So, for the adjudication and to implementation of that injunction order, I had to file that application under Order 39, Rule 7 for proper identification of my property because there is no such identification. That application was filed and being heard and contested. Now the learned trial court kindly see that impugned order has passed that order rejecting my 39(7) application, whereby I sought for that inspection of the property for measurement and proper demarcation of my property. I wanted to demarcate my property. As I am interfered all time, that is continuing day by day, that violating the order. Even if I file the violation application for that, then I am to satisfy the learned trial court that in what respect they are interfering. So there is no such cogent evidence before the learned trial court. For that reason, I applied for Order 39, Rule 7. Now the learned trial court has come to finding treating my application. My lord, may I report that application, my lord? Application and
No, where is the case? Show me from the plaint that there is a boundary dispute being raised. Show me.
in my plaint, I have stated that scheduled property is there.
Yes. Where is the boundary dispute in the plaint? Show me.
There is no boundary. That is the main thing. There is no boundary. I want to get it demarcated and proper.
If there is a dispute, show me there is a dispute. Unless there is a
Dispute is there,
dispute.
my lord, in plain paragraph, page number 14. My lord, can you
In
see?
page 14, yes.
Page 14, I have stated that these defendants has no right, title, interest in the possession over the suit land, manner, but out of grudge and which and all ill and ulterior motive to grab the property are trying to create disturbance in the peaceful possession of the plaintiffs, and that on 18/5/21, defendants, their illegal agent, their agent and antisocial elements tried to enter into the suit land at about 8:30 am.
That is for that you have paid for declaration of title and permanent injunction. There is no boundary dispute. Why local investigation?
Boundary without my lord, without inspection, if it is not properly identified, my lord.
This application under Article 227 of
I am appearing for the
yes.
But in this matter, Order 6 Rule 17 has been filed. This has been rejected by the trial court below. Kindly see the order, the opposite party is the plaintiff, and the petitioner is the defendant in the matter. Kindly see the order. Order the learned advocate of the defendant submitted it, unfortunately, through inadvertence and.
Where is the application for amendment?
Kindly see. Kindly see page 21.
Page
21. Amendment of the written statement, my lord. The material facts have been
by the order in
My lord, to be candid, my lord, when this was filed, my lord, there was no caveat. Yesterday, my client received a caveat notice.
Since,
I should start.
but what is this matter?
Yes, my lord, rejection of my application under order 18 rule 16. Well, I am
16
years recalling.
17.
No, it is my lord.
Order 18.
Sorry, 17. Now, my lord, I am the defendant petitioner in a suit for eviction and mean profit. It was instituted in the year 2006. During the pendency of the litigation, now, my lord, the suit property was transferred to some other party. Now, my lord, there was some dispute, and my lord, initially after transfer, my lord, I came to an agreement with rehabilitation and sale. While this was continuing, my lord, some dispute arose, my lord. I filed a fresh suit against the person who, in favor of whom my suit property was transferred. In the said suit, this plaintiff was a party. Now, my lord, during the proceeding, my lord, my defense was struck off by an order of this court, my lord, for non-payment of, my lord, the area of rent. Examination complete, it was argument stage. Admitted the argument stage. There, my lord, at the time of argument, that case has been made out. At the time of argument, now, my lord, some questions were required to be put. That is why, my lord, a very innocuous questions were put. Lord, so kindly come to page 30. Page 30.
Page
30 of my application. Since, my lord, in the subsequent suit, the plaintiff did not file any written statement. Only this page 33 schedule.
Yes.
Page 33 schedule. Is it correct? Your defendant number 1 in the title suit number 1217 of 17.
This is the subsequent suit.
Subsequent suit.
How that is relevant with this?
No. Subsequent. Well, these questions, because, my lord, in subsequent suit, the plaintiff, this present plaintiff is the defendant number 1.
That records will show.
Yes.
Records will show, and how the whether is the defendant in the subsequent suit, how does it matter?
Because, my lord, the suit property has already been transferred.
All right, prove that. Yes, it's not relevant.
No, it is, my lord, argument. It is at the stage of argument.
Maybe.
That is,
and sir, your defense has been struck out.
That is
if your defense has been struck out, you have a limited right of cross.
That is why, my lord.
So
cross-examination.
You cannot make out put your defense case on merits in cross-examination.
No, not that. Not the only.
That is, sir, you are trying to make out your defense case in another suit by way of cross-examination, putting some questions. Modula India, please bring Modula India. Restricted cross-examination. What is your right? Thank you.
Thank you. Now, question number 5.
Is it correct defendant of that suit not relevant?
Not relevant.
Yes.
Last
Did
question.
you file the written statement in the said suit not relevant?
More than 5.
Is it correct that you are not a party to the
rehabilitation agreement in respect of the
document in that suit? You prove that.
No, it is, my lord. It is.
What is your case here? You have to prove your case here. Cannot prove your own case. Defense has been struck off.
Defense has
in a roundabout way, you cannot do this.
Defense has been struck off. No, this only, my lord, 4. My lord, kindly 1, 2, 3, my lord, I am not on.
Yes.
4 and 5 are relevant. Because, my lord, I did not get any opportunity, my lord, to, my lord, come this fact on the record.
This is all relating to a separate suit. Ashun, this application, thank you. This application under Article Yes.
Lord, the petitioner is a tenant uh, a- in a suit filed under Transfer of Property Act, wherein he has come before me, Lord, on rejection of his application under Section 104. My Lord, the fact of the matter, my Lord, is that in an earlier suit there was a solenama. The solenama consists of the repossession. My Lord, if your Lordship kindly comes to the solenama, that starts at page 15, my Lord. Page 15, and the clause of
Transfer of Property Act.
my Lord, I have no, no.
Yes.
Yes. My Lord, there was a clause, if your Lordship kindly turns to page 16, my Lord, there is a clause, clause 8, which states that in case of a default, I'll be evicted and he have a right of rent. That is there at page 16, clause 8, my Lord. Thereafter, my Lord, there was also a clause, my Lord, that repairing would be carried out of the shop room, wherein 50% would be paid by the tenant, the other 50 of the landlords. So, my Lord, we made an expenditure, and that expenditure, we, my Lord, I would say, adjusted it with the rents and also all these things, and thereafter we started to extend rent, but he refused, and on the ground that there is a no printed bill, so we extended it by money order, and thereafter, my Lord, it come back refused because it cannot be deposited and it is not guided by the West Bengal Premises Tenancy. My Lord, subsequently filed a suit. This suit, my Lord, the plaint is there, my Lord. The plaint is
Suit on what ground?
Huh?
Suit for eviction on what ground?
On grounds of forfeiture and other grounds.
Show me.
My Lord, the suit is
Not under Section 106.
My Lord, notice under Section 106. My Lord, the question is, he has claimed forfeiture. My Lord, both in the notice and in the suit. So, if a forfeiture is there, my Lord, if your Lordship kindly turns to 111 once, it is guided by 111G because he has claimed.
Where is the plaint? Where is the plaint?
My Lord, plaint. My Lord, the plaint, my Lord, is at page 35, my Lord. It starts as page 35. And before that, there is a notice. It starts as page 35. The third is default, claiming forfeiture. Fourth is also that, but since the defendant not pay any furthering rent to the plaintiff. So this is also a case of forfeiture being made out. And thereafter, no claim in the plaint that I am waiving this. But not 3, 4. And the notice also speaks of this forfeiture. Notice is there, my Lord, at page, my Lord, 31.
You have received the notice.
Huh?
You have received the notice under Section 106.
We have received it.
What remains? What remains, sir? I'm passing a decree right now, here, from here.
My Lord, subject to a Lordship consideration.
You can pass a decree right now, 106. Nothing necessary.
My Lord, question is the notice itself claims for forfeiture. The plaint itself
Maybe
claims for
106 is also there. There are many grounds available for termination of the lease. One of is 106. 106 requires service. If you have admitted service, nothing remains, sir. I can pass a decree right now.
My Lord,
from here, I can pass a decree, sir.
My Lord, in case of forfeiture,
It's a division bench judgment also.
My Lord,
Division bench judgment also it can be passed. It's only required 106 service of notice. Please kindly come to 106. What
My
does
Lord.
it say?
My Lord, the nomenclature of the notice.
Maybe 106
But
is.
he has claimed the forfeiture. my Lord.
Maybe, sir, 106. If there are different grounds, he can choose one of the grounds.
My Lord, the 106, my Lord.
Yes. And 111, if you kindly come. So this is the
111
more.
G. It is not guided by H, my lord. It is guided by because
Why
my lord,
not H?
kindly have a my lord, kindly have a
Why
perimeter.
not H? He has also served 106 notice. Why not H? You are taking G, also H. Notice. It's not the choice of yours. It's the choice of the landlord. Which one he will
He has
invoke.
also claimed that in the
Maybe.
he has claimed it in the notice and also claimed that in the plaint.
Sir, maybe this is a
If
determination.
I am asking this question to myself, my lord. If it is claimed in the plaint, that is a forfeiture is a ground.
Sir,
So if the forfeiture is a
sir,
ground,
please take instructions. Please apply your mind. If you say notice has been served, that's good enough. Nothing remains to be proved. In a suit under section 106 of the Transfer of Property Act, that's the only dispute. And if you accept that, decree has to follow.
I'll come on. My lord,
And you are admitting notice served, you are arguing.
my lord,
So
my lord, I'll come back.
degree automatically has to follow. Nothing remains. On the basis of your admission and thus the division bench judgment on order 12 rule 6, decree was passed. Merely on the basis of that admission. And here you are admitting, I can record your submission, I can pass a decree right now from here.
That is a defense, my lord.
By admission also it can be passed. And you are admitting that it has been served.
Lord, please. My lord.
That is the only defense, sir, in a suit under Transfer of Property Act 106. That's the only defense that the notice has not been served. So if you admit notice has been served, end of the matter, nothing remains.
Lord, let me come back with it. My lord,
I think you contest, nothing is, I can allow you, or if you are on 106 notice, then decree will follow from on the basis of the admitted facts.
my lord, let me come.
Order 12 rule 6 is also there on admission. It can be passed. That's the division bench judgment.
Your lordship, if your lordship, my lord, I am not aware of it. If your lordship kindly have a reference to that judgment, I'll come back on it.
Reference, I do not know. Only 106. Even without that, 106, only dispute is whether the notice was served. 111H says on expiration of the period under section, notice under section, that period has expired.
Lord, if your lordship,
That period has
once
expired.
it is a G, my lord, that claim has been made.
Sir, you are not understanding. That's the difficulty.
I understand. Your lordship
H,
is telling.
both are there. He can choose when H is there, why he will go to G. And if that is served, you have admitted that. End of the matter, least determined, decree will follow.
Nothing is written in the written statement, my lord, whether.
Now you are admitting, you are saying, you are inviting the court to the notice. When you have annexed that notice.
Yes, ma'am.
So this shows you have accepted that. Nothing more is necessary, written statement. This can be accepted. Because you have filed this revision application, this is on oath, on affidavits, can be treated under order 12 rule 6 to be your admission.
My lord, let me come back. Let me come back.
After some argument, the learned advocate
Item number 26.
My lordship, I am appealing for the petitioner.
The case by the last
This is
occasion.
my case, your lordship.
Asking my learned friend to submit what are the policies in the
Yes, yes.
Now, my
Lordship,
lord,
I am praying for a
for
time
the
for some time, your lordship.
No.
It's on my fault, your lordship. The order, I couldn't communicate the order, was uploaded
He
after a
was
few days. I
busy
need
that
some
is
more
I
time
know.
to get back for filing the affidavit. I have the
When
instruction.
do you want?
At least a fortnight's time, your lordship.
Fortnight
Because
time.
a week's
My
time,
lord,
then your lordship, a week's time.
Why fortnight's time? You have all the documents. You can file.
Your lordship,
I'm keeping it on Monday, Mr. Ganguly.
your lordship, I have to file an affidavit.
Or you don't have. or you don't have the documents.
Your Worship, then
Please-
give me on
please
Wednesday.
bring the documents with
Wait,
you.
Your Worship, send me and file an affidavit. That's why I'm saying. Give me on Wednesday.
Alright, I will allow you time. Bring the documents to show. I will allow you to file.
Make it on Wednesday.
I'm making it not today only. Not today. Yes, call the next matter.
Deeply obliged.
27, my lord, I am appealing for the petitioner.
Yes.
My lord, what happened, my lord? This is against, my lord, a refusal of an ad interim order by the misappellate court. My lord, challenging an order whereby the injunction application has been, my lord, refused. My lord, initially ad interim injunction was granted in my favor, my lord, protecting my possession. Now, my lord, suit is for declaration of title and permanent injunction. Now, what happened, my lord, in that suit, my case is, my lord, as made out, is, my lord, the original owners.
I'm directing the miscellaneous appeal to
My possession, because I am in possession, they are admitting. Their case is they are co-sharers. So, my lord, they are admitting my possession also. My lord, I am at the appellate stage, kindly protect my possession. That is admitted. Now, my lord, court says, the appellate court says, if my lord takes up, says that the plea of my lord that the erstwhile owners have partitioned among themselves, my lord, cannot be taken. It's the defense of the defendant that under Land Reforms Act, my lord, oral partition has no place. It has to be registered partition by way of a registered deed.
Yes, what is the suit for?
My lord, suit is for, my lord, I say, my lord, my original owners from whom, my lord, I have got the properties, my lord, they have partitioned between themselves, my lord, and they have given the property to me in a demarcated fashion. So, my lord, original owners are giving the property to, my lord, subsequent the plaintiffs in a demarcated fashion. So, my lord, I am now the exclusive owner of the plot.
Yes.
Now, my lord, I claim my title. Now, my lord, the defense which comes in, my lord, in the objection form is that the original owners, my lord, have not partitioned, and this plea of oral partition and, my lord, giving the property in a demarcated form will not stand because this is not a party. There is no registered partition deed. Now, my lord, on that basis, the court has went and said, my lord, the trial court and, my lord, at the identity stage, the misappellate court has said.
Yes, what is the entire extent of the property?
My lord, yes, kindly takes up my plaint, my lord.
Yes.
Page 27.
Yes, 27.
Yes, my lord, my schedule. Oh, sorry, my lord, the schedule to injunction, plaint is, my lord.
Page 20.
20.
Yes.
Same schedule, my lord.
Yes.
Now, my lord will find, my lord, I have stated 1.5 decimals in two plots are involved. 1.5 decimals of land in LR Dag number 838 corresponding to such and such, or less 4 decimals of land belonging to LR Dag number 841. And these are the boundaries given. So, we have specified.
Where is the record of rights to show
Lord,
that you are in possession?
that is not annexed with this
Then-
revisional application.
Then, Mr.
But-
Chatterjee,
Now, my lord,
what documents you have produced
my
to show that
deeds,
you are in?
my deeds were there before the court.
Show me the,
My lord, my
no
deed,
documents you have produced to
my
show.
deed, my
What?
deed, by virtue of which I got the property by registered deeds.
When?
My lord, this
What
I
is
have got
when?
it. My lord, as per the plain case, my lord. My lord, 2017, paragraph 3 of the plain, page 60.
Where is the deed?
Deed আছে? Deed বোধহয়।
What is the extent of the pond?
Well, pond is just kindly takes up well, pond is 13 decimals, if I'm not.
So you are only 1.5.
1.5. No, there is land also. Land also. Well, there is pond and land both.
So pond cannot be demarcated.
It doesn't call for partition. It cannot be demarcated in that way.
Yes.
Land
You also cannot pay for injunction in that way.
land is not.
But what was your payer for injunction?
Milord, on the kindly takes up injunction application, Milord, on 2 plots.
Yes, so also on the pond, you paid for injunction.
Milord, but on the land it will be there.
Yes, land, yes. Which portion you are entitled to? What is the entire extent of the land?
Land, they say, Milord, it is 39. Total is 42, 13 is pond, and Milord, rest is Milord land.
Yes, but
So
you are
Milord,
not the exclusive owner of the entire.
I am not
So,
the exclusive.
Chatterjee, which portion you are? Have you implemented the other co-sharers?
Milord, the parties who are disturbing my possession, who claim
Co-sharers are there.
No, my lord.
Co-sharers
I said, Lord, I am the exclusive owner because the original owners have
cannot be
partitioned
the
out.
exclusive owners. Show me the record of rights. Cannot be the exclusive owners of that plot. That is why the Lanet appellate court was right,
Lord,
saying that
kindly seize-
everything is vague.
Kindly seize, my lord, my deed.
Mr. Chatterjee, I am directing the miscellaneous appeal to be heard. I think that's better. After here,
The oral part.
Filed without the typed copy of the handwritten orders.
is it legible?
Legible. No, it is legible. It is
If it
legible.
is not legible, it will be rejected on
No,
the.
my lord, it is legible.
Lift.
mention one urgent thing. My lord was pleased to pass an order in contempt matter 22/2025. And
22/5.
25, 22 of 2025.
Yes, yes.
Contempt matter.
Yes.
Order was passed on 7th August.
Yes.
Yesterday itself, I mentioned this. Scheduled on 17th. So
Call it.
that's why.
Yes, call the list.
Item number 28.
Yes.
Plaintiff is the petitioner before Milord put for declaration of title. The order under challenge is whereby Milord, an advocate commissioner is appointed Milord for conducting a local inspection. Milord under Order 39 Rule 7. Now Milord, if Milord takes up.
Why are you aggrieved?
Milord, I am aggrieved Milord because there is no requirement. If Milord takes up the local inspection
Only a piece of evidence will be beneficial.
Milord, there cannot be Milord fishing out of evidence, Milord, and that too, Milord, in this type of
Some
application.
amount of fishing out of evidence is there in all local inspectors.
Milord kindly looks at the reason, Milord, why he seeks Milord an advocate commissioner, Milord.
Page what is the
35.
suit for?
The suit for declaration of title and permanent injunction, Milord. In that, Milord, they file this application, Milord. Kindly takes up paragraph 2.
Page?
Milord, page 35. Milord, kindly sees. They have filed an proceeding before SDEM court, for which Milord they file an application in civil court.
No, is it for violation of an order of injunction?
No.
Yes, yes. Despite
Milord, where is that application? Milord, may I put this question to myself? Milord, he says, he alleges that I am violating. I have obtained an injunction and I am violating it. And for this reason, the defendant has to file one miss case 293 of 2025 before learned SDEM at Luberia for urgent necessity to restrain the plaintiff. Well, for this, Milord, Order 39 Rule 7 in this title suit, where Milord in defense when they enter appearance, they do not raise this Milord contention. Nowhere. Neither in the objection to the injunction.
But if you are violating, Mr.
So, Milord, I am not violating. I am not at all. But let them allege before the civil court. Milord, my contention is.
SDM is by mistake.
Milord, SDM will send the police to file a report. Commissioner from civil court will go to find. Milord, file it before SDM court.
No. May not be before SDM
then,
court.
Then kindly direct the SDM proceeding to stop.
That is
Milord, that's exactly what I am praying for, Milord. Police will go and find because SDM court will direct the police to go and file a report.
No application for violation of
nothing. Rather, there is my application for implementation of police that is being allowed.
But Mr. Chatterjee, they have said that in violation of the order of injunction,
there is something to aid in the suit. Milord, my question is, Milord, there has to be something on record.
By the order. Yes, Mr. Manager.
Formula rejection of an application under Order 39 Rule 7.
Suit for Milord declaration and injunction. Declaration.
Mr. Banerjee, Mr. Raj, can I take up this matter?
Yes, yes, I have encouraged, at least.
Yes.
Milord, declaration of title saying Milord on an assertion that Milord this is a Milord key land was a Shali land and injunction to restrain me Milord from disturbing his possession. Milord, this
You are
is
the defendant.
I am the defendant. Milord, I took out an application under Order 39 Rule 7 for the purpose of Milord ascertaining the exact Milord mode of occupation of the possession of the property Milord in present time and Milord the status of the property because Milord my case was that Milord there is Milord now a residential complex which has come up and Milord this is no more Shali land as is being Milord alleged. So Milord I just wanted Milord the learned court to be apprised of Milord the exact nature of occupation of the property in present time. Milord that was Milord my application and that has been rejected Milord on the ground that Milord I am trying to Milord fish out evidence and that is not necessary. Milord the plaint is at page 24. Kindly see Milord the scope of the suit. Page 24, Milord, paragraph 1 says this is Milord agricultural land and Milord he is there. Paragraph 4 says Milord we made an attempt Milord to enter into the property and all and if there is any document Milord in our favor Milord establishing our title to the property, all those documents Milord, though Milord the allegations are absolutely vague, does not Milord particularly refer to any instrument or as such. Those documents are all Milord fraudulent, etc., etc. And then Milord prayer is nalishi jomite sholoana dokhol thaka sabboste. So Milord declaration sabbosto প্রচারে যাহাতে বাদীগণের দখলে বিবাদী লোকজন বাধা বিঘ্ন না সৃষ্টি করতে পারে. And Milord my application of Milord under Order 39 Rule 7 is at page 52. May I have also filed written statement. Page 52 is Milord my application.
What is your case? This is the case made out in the written statement?
Yes, Milord.
What
So
is
that
the
is
case?
what my written statement is all about. Milord, page 39 is the written statement.
So what is the case?
My case is that Milord, I own the property. Milord, this was sold to me Milord under court sale by this honorable court Milord in company jurisdiction. Property was put up for sale. Milord, this was sold to me by the honorable court. And Milord, now I have Milord title deeds in my favor. And now Milord, there is a residential complex that has come up. Milord, I have annex photographs also. That Milord, there are multi-storied multiple buildings. And people have started residing there. So that Milord, he is claiming that this is a Shali land and Milord, he is in occupation. We are trying to disturb his position. Milord, that's not factually correct. But Milord, consciously, Milord, we did not. Milord, take out an application under Order 26 Rule 9. Milord, we filed an application under Order 39 Rule 7 only for the purpose of apprising the learned court of the Milord modus of occupation of the property as of now. And
For what purpose, Mr. Banerjee?
because Milord, the suit is for Milord perpetual injunction so that his possession is not disturbed.
Suit for declaration of title and permanent injunction.
True. Permanent
So
on an assertion.
that declaration of title can be proved by documentary evidence.
Milord, I am also,
You also are trying to claim title
it's not
with regard to
commissioner's
the
job. Yes, not the commissioner's job, Milord, to ascertain the title. So,
also
Milord,
possession.
possession is what is Milord contemplated under
Possession,
Order 39 Rule
can
7.
describe the possession.
Milord, it's not possession.
You
Milord,
are
it's
trying to. That
mode
is what
of
Mr. Banerjee, you are trying to
Thank-
do by
mode,
way of local
no,
inspection.
mode of occupation of the property, modus of occupation of the property. That is what
That
Milord
is
Order 39.
possession.
That is what Order 39 Rule 7 is meant for.
Mr. Banerjee, for what purpose?
Milord, kindly have a look at Order 39 Rule 7 with the
I'm
provisions.
asking you for
Yes.
what purpose you have filed this application.
Milord, the learned court
Because
was
according to you, you also claim title.
true. Milord, I am not
In
on title.
possession has to be proved by way of documentary
Milord, for
evidence.
what purpose the property is
Also-
being used now? Milord, that was the only requirement, Milord, of Order 39 Rule 7. Milord, the
Even
learned court must
even
know that.
Accepting, yes, it's a residential complex have come up.
Yes, Milord.
Does it prove your title?
Milord, I am not on title so far as my Order 39 Rule 7 is
So what
concerned.
do you want to prove?
Milord, I want to, Milord, if I say I want to prove, Milord, I will possibly come under Order 26 Rule 9. So, Milord, I do not say I want to prove. Milord, I say that learned court must know, Milord, for what purpose the property is being used now. Milord, that will have, Milord, an impact on, my lord, the pending injunction application as well, which is, my lord, the purpose of Order 39 Rule 7. It is not, my lord, fishing out of evidence. That is what Order 39 Rule 7. Injunction application is pending. And, my lord, without knowing the, my lord, mode of occupation, my lord, the purpose for which the property is being occupied, my lord, how
What
do
are the
my lord-
points of local inspection?
Yes, kindly have a look at Order 39 Rule 7 application, page 52.
It's 60.
Page 52, my lord, it starts. The application schedule is at page 60. My lord, one is, my lord, I can confine myself to one. Three, my lord, I can understand. My lord, I was over ambitious a little. Three, I can understand. But my lord, one,
so you are only on one.
I'll be happy with that. And that's, my lord, necessary for, my lord, hearing of injunction application also. The court must get, my lord, this aid. And, my lord, do not understand, my lord, why they are feeling shy of, my lord, this disclosure. Lord, I must also tell your lordship, there is one more revisional application pending from this suit before your lordship. That is from, my lord, rejection of Order 7 Rule 11, which is not there in the list. My lord, if I-
Yes. So you are restricting to one only.
Yes, my lord, kindly allow me to restrict myself to one only for the time being. Three, my lord, I understand, my lord, as an officer of the court is over ambitious.
Where is the application for injunction?
My lord, injunction application is not annexed here. That's no, my lord, not annexed. But, my lord, this is in consonance with, my lord, the plaint. My lord, in consonance with the prayer for perpetual injunction.
No, injunction application is not annexed.
It's not annexed here, my lord. But, my lord,
So
this
do you
is-
have a copy of the injunction
as
application?
of now, my lord, I do not. আছে কাছে আছে না না কাছে এখন আছে সেটাই জিজ্ঞেস করছি but my lord, this is just, my lord, a word for word reproduction of the plaint, and instead of perpetual injunction a temporary injunction is what is prayed for.
Yes. Now, what is the finding of the learned
Yes,
trial?
my lord, kindly have a look at the impugned order. It starts from, my lord, page 2, slightly, my lord, down below. The defendant has filed local inspection application.
Please give me a minute.
Oh, my lord, I have, my lord, the injunction application with me. এটা কি annex করা রয়েছে এটা? Oh, my lord, I am sorry, my lord, I was wrong. Page 36 is possibly the injunction application. I'm sorry, my lord, I missed it. I'm thankful to my learned attorney. It's there, my lord, page 36. Thank you. So where from he is getting all these things, my lord, I really did not understand. Who is asking for bifurcation, my lord? It's not me. It says the fact of possession of suit property is a crucial relevant fact to the fact in issue of title of the properties. Henceforth, information collected as to possession of the suit property by of any inspection must be in the form of evidence, which is certainly not a report under 39(7). My lord, the observations are all in my favor. My lord, the learned judge, my lord, put my case, my lord, even on a higher pedestal. I did not run, my lord, that higher case.
You have constructed a boundary wall.
There is a boundary wall surrounding, my lord, the land. The entire land.
Plots. How many plots?
My lord,
Boundary wall surrounding how many plots?
multiple, including, my lord, the suit plots.
How can a local inspection commissioner decide which plots are within the
My
boundary
lord, if
wall?
both the parties, my lord, cooperate with the, my lord, local.
Can it be decided,
That
Mr.
Banerjee,
Banerjee, without investigation?
My lord, the locus, let the commissioner go and, my lord, come back and say that, my lord, the locus of the, my lord, suit land is
Mr.
in
Banerjee,
dispute.
if, let us assume, plots more than the suit plots.
Yes.
So according to you, you have purchased many plots, including
Suit
the
plots.
two suit plots, two or
Right,
three,
two.
including the two suit plots.
Right.
And you have encircled all your plots which you own
Correct.
by a boundary wall.
Correct.
Then you have made construction or you have obtained plan, whatever, those are other things. So how can a commissioner, advocate commissioner, after going to the portion which has been butted and bounded by a boundary wall, decide in which portion of the butted and boundary wall construction is there, and whether the suit plots are within the boundary or not?
My lord, order.
Can it be decided without local investigation?
My lord, I have twofold answer to that. Order 39 Rule 7 is not, my lord, restricted to the suit property only. Order 39 Rule 7 can be, my lord, made applicable to, my lord, other properties also which are not directly involved in the suit. My lord, that's a
So
rudimentary.
whether
principle of law.
whether it's
Number
within
one.
the suit property or outside the suit property, be
Now-
specific on that.
I'm sorry, my lord.
Whether this is within the suit property or outside the suit
My
property.
lord, the suit property is included in the, my lord, residential project.
How that? Because Mr. Banerjee, if there are
My lord,
several,
there is, my lord, there is,
how that can be identified
Sir,
which
that is
portion is
not,
the suit
my lord,
plot.
that is not in dispute. My lord, the locus of the suit land.
They have admitted that their property is within the boundary wall.
Let them
Show me
say,
that
let
admission.
them, my lord, say no. Kindly, my lord, have a look at their opposition to, my lord, the Order 39 Rule 7 application.
Yes.
Nowhere they have said that, my lord, this is not within, my lord.
No, Mr. Banerjee, show me that they have admitted that the suit plots
My lord, they have avoided saying anything about that.
Mr. Banerjee, please show me that you have asked you that whether they have admitted that the suit plots are within your boundary wall and in your possession.
My
Show
lord,
me that.
My lord, if my lord is, my lord, on an unequivocal admission, that is not there. My lord, they just avoided, my lord, answering to this. My lord, they just said that, my lord, there is a residential project which has come up.
Yes.
Nothing more, nothing less.
Well,
kindly, my lord, have a look at their, yes, 162 is their objection.
Yes.
And they were more on, my lord, this fishing out of evidence.
No, fishing out of evidence is a different thing
Yes.
altogether. But
Yes.
considering the fact that if it is only the suit plot is one thing. Now, when several plots have been encircled by a boundary wall, the local inspection commissioner
My lord, let him come back and say that, my lord, he could not ascertain whether the suit plots are within the boundary wall or not.
How can that
This
be?
is not,
Mr. Banerjee, without relaying, cannot be done.
My lord,
And that cannot be done by an advocate.
my lord, each one of us, my lord, has a Mausa map. Each one of us, my lord, has a Mausa map.
Banerjee, an advocate who is not a trained surveyor, can identify.
My lord, the locus of the land can be identified, my lord, by any prudent person. My lord, for that an expert is not required.
I do not know, Mr. Banerjee, 5 plots, 6 plots, or more than 2 plots, the suit plots, you can identify.
He need not, my lord, pin.
Banerjee, then there is no necessity for that
26 rule
passing that. No, not on 26/9, for passing of that examination.
Oh,
survey.
But kindly have a look at
that.
the,
Is not necessary. Because we are facing trouble because now those courses have been stopped. If you say so, then we will say yes, advocates can do that. Cannot be done, Mr. Banerjee.
My lord, we did
That's
not.
the specialized course.
My lord, I do not want, my lord, the advocate commissioner, my lord, to go there and pinpoint the land. My lord, what I want is, my lord, only the advocate commissioner only to say whether, my lord, the suit land is there inside.
Cannot be done, Mr. Banerjee. If
my lord, I tell your lordship,
only
why I say this.
are there, it's one thing.
Yes.
If there are several other plots, so it has to be identified which portion is the suit plot, which portion is the non-suit plot.
My lord, that is not the, my lord, requirement of my Order 39 Rule 7 also. I do not want, my lord, the commissioner to go to that extent. My lord, I tell your lordship, my lord, the residential project is, my lord, just by the side of a highway or, my lord, a road, main road. So, my lord, suit lands, my lord, after the highway, my lord, the suit, the land, my lord, land start. Milord, there is a boundary wall, Milord, encircling, Milord, a larger property just, Milord, by the side of the highway. Milord, on the other side of the highway, Milord, there runs a canal. My lord, can Milord visualize, Milord, the location of the property. Now, Milord, there is a schedule to the plant. The schedule to the plant has a, Milord, boundary. Milord, one can easily ascertain whether, Milord, those shoot lands, Milord, have been, Milord, engulfed in the residential project plot or, Milord, residential project or not. Milord, I only want, Milord, the commissioner to say that yes, the shoot lands are there inside the boundary wall or inside, Milord, included in the residential project. That's what. Milord, I only want, Milord, the commissioner, Milord, to come back and, Milord, tell the learned court. Because, Milord, if the learned court today proceeds on a basis that, Milord, agricultural activities are going on without even knowing, Milord, what is the, Milord, nature of
Agricultural
the land,
activities, whether it's going on or not, that's a different thing
Milord, that will have an impact, Milord, on the adjudication of the injunction application. Otherwise, Milord, the learned court
Page,
has
what
to.
is the injunction page you said?
Well, 36 is the injunction application.
36.
36. Otherwise, Milord, the learned court has to act blindfoldedly, completely, Milord, while adjudicating upon this. Kindly see, Milord, the prayer. And kindly, Milord, have a look at the averment. My lord was looking for, Milord, a kind of admission. Milord, I do not call it an unequivocal admission, but kindly have a look at the tenor of their averments. Page 37, paragraph 3. And this was, Milord, in 2015.
What is your objection against the injunction application?
This written statement is there at page 39. And my
your positive case in the written statement.
Yes, Milord. Milord, it starts from the foot of page 39. I say that, Milord, one company was there who was the owner who had gone into liquidation. Milord, the property was put up.
With 39.
Page 39, Milord, the written
Yes.
statement starts.
Yes.
Milord, towards the foot of page 39, paragraph 6, Milord, subparagraph clause A. Milord, I said this Dominion Rubber was the owner who had gone into liquidation, winding up proceedings started. Milord, the property was sold. Saint Pundit, Milord, was nominated, Milord, as the purchaser. The property was sold, Milord, to Saint Pundit, and then, Milord, that was sold to me. That's, Milord, my specific case. And I have also annexed to my written statement, Milord, the
So, with
instruments.
regard to this construction and other things, very
Yes, Milord, kindly. Yes. Kindly, Milord, turn to page 43.
Yes, page 43.
Milord, clause M at the foot of page 43, I have said that, Milord, this has been mutated.
Yes.
And then this is, Milord, on title.
No.
Written statement is
on
title.
injunction, construction and other things.
Milord, those have been disclosed. And Milord, photographs have also been annexed.
No, no. Where is there your case in the written statement with regard to that?
Milord, Milord, this was a written statement of 2015. Suit was of 2015. Today we are in 2025.
No, but those in the injunction you have said in aid of injunction this is so either you have.
Milord, I have used, Milord, a written objection separately to the
Written
injunction
objection was
application.
filed must be prior to
Milord,
written
recently.
statement.
No, no.
Prior to written statement.
No, Milord, possibly no. Milord, I have to inquire that, and the objection is not here. If my lord wants to see the objection, Milord, I can bring that.
Because in the written statement you have not
No,
read out that
no,
case.
because, Milord, the construction was, Milord, about to start then.
Yes.
Possibly. Milord, I can bring. But, Milord, I
regard
can
to
have a
the
look at.
boundary wall being constructed, nothing.
Here, Milord, there is
all
nothing.
these plots you have
Kindly, Milord, just
encircled
have a
that.
look. Kindly, Milord, have a look at page 158 once.
What is 158?
158 is, Milord, the present status of the property according to me.
No, no, that is the photographs. I am not on the photographs.
Milord, page 64 are, Milord, the sale agreements with the individual unit holders. Milord, they have come and, Milord, taken
Mr.
possession.
Banerjee, you
Milord, I will, Milord, just take.
Mr. Banerjee, those can be proved. For that, local inspection is not necessary.
required, not
You can prove your purchase, you can prove your right to construct. So,
This can be proved by documents.
everything,
By
and you
documents.
have raised the construction. You can also, Mr. Banerjee, you must be having some documents to show your completion.
Action plan and all, well, those things.
The construction has been completed.
My lord,
For
is
that,
looking for-
documents will be there. Agreements for that, documents will be there. What for local inspection?
My lord was looking for a statement from their end that my lord on the suit property, my lord constructions have come up. My lord, I have shown my lord from their my lord injunction application that my lord back in 2015 there was an allegation that we are trying to my lord construct my lord on the land.
Yes.
So my lord, kindly allow me my lord to come back with the written objection to the injunction application. I believe my lord photographs and all my lord
All
everything
these
is
things,
annexed there.
Mr. Banerjee, even accepted. Assuming that you have raised the construction, everything,
Yes.
all can be proved by way of document.
My lord is thinking of the fate of the suit, but I am more on my lord the injunction application.
On the injunction application, not the suit.
Without knowing the present status of the my lord
Mr.
land.
Mr. Banerjee, if you have documents, you must be, I did not tell you, the right to make construction on which plots, their sanction
But
plan,
there is no-
everything is there. You can
There is
prove.
no harm.
Injunction,
The learned court to-
injunction is on affidavits. Injunction is on affidavits. They are claiming that it's a Shali land. There is no construction. So, and your case is that no, you are the owner, they are not the owner. That also can be proved by way of documentary evidence.
Correct.
Though not the prima facie title, but the prima facie case will be going
There is
to.
no harm for the learned court to be better equipped. Miller order
For
certain
what
rules say for that.
For what?
Miller for the
Then Mr. Banerjee, for all things, mechanically an order, an application for the local inspection has to
well,
be
let's
allowed.
come back with the written objection to the injunction application. I'll
Yes,
just
sir.
check Miller
What to say?
Can you turn to page 43? Apart from that, aim.
In. Yes. I've seen that. I've marked that. Before you have placed, I've marked.
Yes, but I've shown that.
Yes, place.
I've shown
No,
that. Yes.
the-
Aim I have shown.
Yes.
What my argument is, so existence of the plot, according to my learned friends, changed.
Existence.
Nature of the existence of the plot in the diameter or in the plate mentioned, that has been changed. It is amalgamated. According to it is 4.5 acres, and the suit plot is 0.4 decimal, 0.40 decimal.
4.369 acres.
4.369 acres.
Yes.
Fine.
So this plot coupled with the others, this has been amalgamated, mutated, and now it is formed up
Yes, yes.
according to my learned friends.
Yes.
What is the suit for? I put this question to myself. The suit for declaration of title permanent injunction.
True.
Today, their case is that they purchased the property, they have made construction, they are in possession. Whether my lord will allow 39(7) to find out who is in possession and what is the nature of user.
Miller, suit for injunction, Miller injunction, Miller to the extent that Miller I should not disturb his agricultural activities on the suit land. Miller, that is the nature of injunction. Miller, my learned senior friend is asking for before the learned code below.
It has been mutated, Mr. Banerjee.
He can put in the mutation.
So, mutation certificate, mutation, current record of rights, that will show the character also.
Miller,
there.
Miller, kindly allow.
Also show the character, Mr. Banerjee.
Kindly, Miller, allow me, Miller, to place reliance on one decision then. Kindly, Miller, allow me. Miller, this is though, Miller, of Andhra Pradesh High Court's decision. I'm sure my lord will not, Miller, castigate me for that.
No, no.
Miller, this is 2005 SCC online AP 982. Achha, a copy de.
2005
SCC online, Andhra Pradesh 982. Which Miller discusses the Miller difference between Order 26 Rule 9 and Miller Order 39 Rule 7 and the purpose of Miller Order 39 Rule 7.
Yes.
At a copy there, Joshua? Kindly allow me a moment.
So, 17 SCC online Madras.
Nago, Andhra Pradesh.
Andhra Pradesh. Where have you gone? To Madras?
Calcutta, my lord.
He has gone to Andhra Pradesh, you have gone to my Madras.
ICJ, whatever he wants.
My lord, kindly allow me, Miller, this is slightly marked.
None of you is within Calcutta. That's the difficulty.
I am in Calcutta. Pretty advocate.
My lord, kindly just have a quick look, Miller, from this page. দিয়ে দিলাম জজ সাহেবকে দাঁড়া হয়ে গেলে বলছি
Paragraph?
Miller, the entire judgment is on this. Miller, it distinguishes, Miller, the purpose of Order 39 Rule 7 and Order 26 Rule 9. Then Miller discusses, Miller, what is Miller Order 39 Rule 7 is meant for. একটাও নিয়ে আসিসনি ডেফিনেটলি। অন্য বৃত্তার মধ্যে ঢুকিয়ে রেখেছিস কেন? অন্যটার মধ্যে ঢুকে এপি এপি অন্যটার মধ্যে ঢুকিয়ে পরের গুলো বার করে রাখ, ধরে বার করে।
Yes, which portion, Mr. Banerjee?
My
you
lord,
are
kindly
relying-
take paragraph minute 9.
9.
And I have got one more copy. Miller, this is unmarked. If my lord kindly takes this. Paragraph 9.
Yes.
The factum of possession relevant to the adjudication of the petitions field seeking temporary injunction shall have to be decided always and in all circumstances with reference to the evidence adduced on either side independent of the observations made. What has been specifically observed and noted down in the report alone merit consideration by the court, which features may elucidate the fact in dispute. The appointment of a commissioner under Order 26 Rule 9 of the Code for localization or under Order 39 Rule 7 for detention, preservation or inspection of any property which is the subject matter of the suit is certainly not for the purpose of collecting evidence. Where the matter in dispute requests further elucidation, a commission can be issued under Rule 9 of Order 26, and where it is necessary for purpose of obtaining full information, the court may authorize the commissioner under Order 13 Rule 7 to inspect any property in dispute, take samples, make observation, conduct any experiment for that purpose. These two provisions operate thus separately and for different purposes. One is to elucidate the fact and the other is to obtain information. Milord, I am on this obtaining of information as on date, mostly for the purpose of keeping on record the existing condition of the property, so that if the same is subjected later on to any change, deterioration, mischief, etc., that can be known to the court and if and when required. Ultimately, the fact in dispute shall have to be decided by the court only on the basis of material which my lord was also on by the respective parties, which is either further elucidated or explained fully by means of a report of a commissioner. However, appointment of a commissioner under I'm skipping over the irrelevant portions. Appointment of a commissioner under Order 39 Rule 7 of the Court for collecting evidence from a perusal of the impugned order. It is obvious that the commissioner was appointed only to note down the physical feature, to draw the rough sketch and to take photographs if necessary. Therefore, the apprehension of the revision of petitioners that it is for the purpose of collecting evidence is misplaced. And so, my lord, I want the commissioner, my lord, to obtain information as regards the, my lord, present status of the property, the existing physical features, and to apprise the learned court, my lord, of those. Just to, my lord, disseminate information. My lord, there is no harm, my lord, in doing that. And, my lord, that will be, my lord, of immense assistance, my lord, to the court to, my lord, adjudicate upon, my lord, the injunction application. My lord, one more, my lord, on this. I'm sorry, my lord, I'm troubling your lordship. I could not find anything from Calcutta.
No, no, no.
Milord,
So Banerjee, those are some things, some observations are on a lighter note. Don't take everything seriously.
1989 Odisha.
That was relied upon here. 89 Odisha. Yes.
Mira paragraph 7. আমি দিয়ে দিচ্ছি, কপি দিয়ে দিচ্ছি তো।
Yes.
উড়িষ্যাটা দে বাবা। Paragraph 7 reiterates the same thing. Kindly see, my lord, what is the nature of dispute here? While the plaintiffs claim disputed land to be a part of their dwelling house, defendant number 1 claims that he has purchased vacant land adjacent to the dwelling house. Allegation is relating to construction of house by the defendant number 1, which plaintiffs intend to assert arrest during pendency of the suit. Defendant number 1 in his written statement stated that he has already constructed a local inspection of the disputed land and its adjoining areas would give a clear picture to the court for considering the question of temporary injunction. But I am on this. Sorry. এই পরেরটা যে একটা মহারাষ্ট্র আছে 1995 এসসিসি অনলাইন বেল So, my lord, the suit property, adjoining property, my lord, everything can be taken into account, my lord, by a commissioner under Order 39 Rule 7. The court must know, my lord, what's going on, my lord, in the suit property now. And the entire Order 39, my lord, is on balance. Balance of, my lord, convenience, inconvenience of the parties. If my lord can weigh the balance,
Yes.
Last but not the least, this is from Bombay. And paragraph 7 of this judgment also আমি দিয়ে দিচ্ছি copy. দাদা paragraph 7. Milord, it says that Order 39 Rule 7 is also, Milord, not restricted to suit property.
Paragraph
7. The only test is, Milord, whether inspection is necessary for determination of controversy. Here, Milord, the controversy with regard to the injunction application. এটা একটা পরিষ্কার।
Yes.
Now, Milord, kindly see the impugned order, Milord. In the touchstone, Milord, of these, Milord, 3 decisions, kindly see, Milord, the test which the learned court applied while adjudicating upon my, Milord, application under Order 39 Rule 7.
Yes.
Milord, I say, Milord, this was, he has applied, Milord, a completely wrong test of law.
Yes.
Kindly, Milord, have a look at, Milord, the second page, somewhere towards the middle.
Order is dated 5th of March.
5th of March.
Second page of the impugned order?
Yes, Milord. Kindly take, Milord, around 10-12 lines, Milord, from the top. Milord,
the plaintiffs have filed written objection.
The defendant, who is also the petitioner of the instant application, has admittedly contended. Milord, the sentence starts like, Milord, the defendant, who is also the petitioner of the instant application. It's, Milord, 1, 2, 3, 4, 5, 6. 8th line, Milord, from the top. 8th line towards the right hand side, extreme right hand side.
Yes. yes, the
The
defendant,
defendant, who
yes.
is also the petitioner of the instant application, has admittedly contended that the suit land has been possessed by the defendants along with non-suit land in the name and title of IDML, that's the name of the project. And in such case, then kindly see what the learned court has held. A report of local inspection shall only be a helping hand of the defendants in order to defeat the plaintiffs in the contest of temporary injunction hearing that is yet to take place and cannot be allowed to ease the defendant's burden. The fact of possession of the suit property is a crucial relevant fact to the fact in issue of title to the parties, and henceforth the information collected as to possession of the suit property by inspection must be in the form of an evidence, which is certainly not a report under Order 39 Rule 7.
Possession, Mr. Banerjee, you are not also saying that can be done.
But I am not.
So possession also.
Milord, what the learned court held is possible, if I have understood this order correctly, learned court wanted to say that I should have approached with Order 26 Rule 9, not Order 39 Rule 7. Milord, one who is entitled under Order 26 Rule 9, he can as a matter of right claim Order 39 Rule 7.
Did not say you have to approach under Order.
Kindly see, the language. It says, fact of possession of suit property is a crucial relevant fact.
Yes.
To the fact in issue.
Cannot be done by the local inspection. That's well settled, Mr. Banerjee.
No, it says henceforth the information collected as to possession of the suit property by of inspection must be in the form of an evidence, leading to Order 26 Rule 9, in the form of evidence. It has to be
that
so.
other evidences. Possession cannot be also by local investigation. Possession also cannot be done.
Milord, kindly see the next sentence then.
Yes, yes.
It is settled principle that the findings of local investigation can only be used as evidence in a trial.
Yes.
The learned court was directing towards Order 26 Rule 9 only.
No. That says that
in a trial, as because it renders an opportunity of cross-examination
distinction between local inspection under Order 39 Rule 7
and investigation.
And 26(9).
Investigation.
26(9), automatically that report forms part of an evidence. That is the learned trial judge says.
No. Learned trial judge then held that if Order 39 Rule 7 is allowed, that will be used as an evidence in trial, which is not permissible. That's what the conclusion which she arrives at. Henceforth, the information, after that, those awards in capital letters. Henceforth, the information which the defendants want to bring on record by Order 39 Rule 7 cannot be allowed as, firstly, because that would not amount to an evidence in trial, and secondly, because such and such cannot be segregated by an advocate commissioner of a local inspection. Nobody wants this segregation. These are, my most humble submissions. These three judgments are, authorities on the proposition that, if there is an allegation that, it's been club, construction has come up on that journey,
can be inspected.
There is no bar, no impediment, no harm, and this would be of immense assistance to the learned court. And nobody should feel shy of this disclosure. CPC table.
Yes. Anything you want to show from Civil Procedure Code?
Order 39 Rule 7, clause B. 1B.
1B.
Yes.
Yes.
It says any land. On A says property which is the subject matter of such suit. B says, in juxtaposition, any land or building in possession of any other party to such suit. Well, that is, the wider scope of Order 39 rules.
No, B is for any purpose,
Can you see,
any person to enter upon into any land or building in the possession of any other party.
Can you see the difference between A and B? Yes. A says make an order for detention, preservation, leave aside those two expressions, inspection of any property which is the subject matter of such suit, or as to which Any question may arise.
This relates to subject matter only.
Then B says,
yes,
for all or any of the process aforesaid. So, Milord, inspection.
That is detention, preservation, and inspection. Inspection also comes.
Yes.
Authority for any person to enter upon into any land or building in the possession of any other party
To such suit.
to such suit, and for all other purpose samples. That's a different thing altogether. So, according to you, in Order 39 Rule 7(1)(b),
yes.
So the other plots also can be inspected.
And Milord, only for the purpose of dissemination of
To support
information.
that Bombay judgment.
Information.
Any other? Yes, Mr. Rai.
So there is no dispute regarding the identity of the property?
There is
no dispute regarding the identity of the property. My suit is based on the fact this is a plot in question, which is subject matter suit. I have to prove my position and title of the property to get a suit for declaration and injunction. His claim is that he purchased the property, amalgamated the same, made construction, conversion, everything has been done. Today, for the purpose of, I put this question to myself. Can you turn to page 60?
60.
60. The point for local inspection. One and one. How it can be segregated? I put this question to myself. Local commission has any authority?
1.
Yes. Page 60.
Land comprised in RS tag number ato in the district forming a portion of land. Suit property is plaintiff's page 25. 26 is the schedule.
Schedule. What is the rule 3?
Page.
To page 26.
1953, 1953, 1955 and 1. Mr. Rai, why 1958 has been struck off?
I say, Milord, I am not owner of the property.
He said
1958, I am not claiming.
All right. That is why it's your, this cross is by you. But the 3 plots are the suit plots. So 1953 and 1955, he says forming part of the land described in the schedule of the plaint. What is the meaning of this, Mr. Banerjee? I also cannot understand point number 1. It forms the part of schedule A. So you want whether those are forming part of the land described in schedule.
Milord, I say whether the land comprise, sorry, Dada, land comprise in dag numbers 53 and 55, that forms
a barren land or is being used for agricultural purpose.
What is the activity which is presently going on in such land?
Yes.
Forming a portion means that forms a portion of the land described in the schedule.
So, Mr. Banerjee, you are restricting only to point 1. I will record that.
To do one page, but kindly do not record it, my lord. Kindly make it a court's order.
Not court's order.
Now it is because
my own way. Court's order will pass orders in my own way.
Because of this streaming, nowadays we have lost independence.
No, Mr. Banerjee, you are free to. If you say you are placing all points, that is why I'm asking you. I'm not putting anything on you. If you say you are only restricting your claim only on point 1, I will consider point 1. If you say
I'll immediately take instruction, Milord. I'm sure, Milord, I'll be allowed to restrict myself to 1. I'll immediately take instruction.
Because then I have to record that you are restricting only with regard to 1. Yes.
And Milord, 4 is there. If the court fits, if the court fits.
Any factual issue, controversy,
my lord, Milord,
that is vague, nothing. 4 is, yes.
Today, my lord,
is omnibus.
Today is, my lord, whether this local inspection is at all applicable or permissible under the law or not. That is the only thing.
No, according to Mr. Banerjee,
it is
only the local features. What is there? What is the harm in that?
Yes. Today, my lord, if you logically consider what is the case, my lord is considering all these applications, in the aid of the final relief. All the interlocutory applications and all the prayers are made in the aid of the final relief. Now, what is the final relief? What I require to prove? And it is an enabling provision. You logically consider Order 39 Rule 7 is the enabling provision. Order 26 Rule 9 is the provision for the purpose of adducing it as evidence. 39(7) is the enabling provision of the court to consider whether it is necessary or not, be as it may. Today, these are the issues before the court. What is the issues? According to me, I am in possession, I am the owner of the property. I have to satisfy the court that possession cannot be looked into by the commissioner. So what is the mode of users? If you are logically consider, if today by learned friend is wanting that what is the mode of user of the land? First,
Please let me understand. Yes.
We are restricting to one.
Yes.
Only with regard
On
to
instruction. On instruction.
Then, my lord, if you logically consider, if my learned friend is not willing to consider 95, 53 and 55 regarding the possession, then who have constructed, how it is constructed, how it can be segregated? Assuming the construction is there.
No. Please make your submit because I was
Yes,
recording
sir.
Mr.
Sir,
Banerjee's
sir.
submission. That is why.
So today the commission has to consider which are the plots or the suit plots. According to, if I take it, all the statement made.
No, he says it should not be restricted to suit plots. All other non-suit plots also can be inspected.
Inspections, first he has to inspect these suit plots. What are the suit plots? Is the amalgamated now in their documents they have said they have been.
Suit plots are not amalgamated. Suit plots have been amalgamated with other plots.
That is why 0.4 decimal now the condition of construction has been made. So first he has to segregate. That is the question I want to put forward. Whether this is permissible before that, after that, whether it is used in such a manner or not, that is something. Identification of the property. If I take it into account, all the statement made by Noel Arnett is correct. Whether it is permissible under 39(7. When according to him it is amalgamated. Construction project has been come up with by amalgamation. Whether 39(7 is permissible for identification of the plot. Unless until there is identification, there is no question of how it is being used or continue to be used. So whether this 37 Order 39 Rule 7 can be considered for that purpose. Position, my lord, now my lord, can you consider what is arguing for the in the aid of injunction application? My lord, can you consider today the injunction application objection? What are the statement made that he purchased the property and he has
No objection. I do not have. Do you have the copy of the objection?
Objection টা আছে? Injunction objection টা আমাদের কাছে আছে?
Yes.
In the written statement, my lord will find there is nothing to that extent. So what statement has been made in the application?
That is the injunction of objection.
Yes.
আছে লাগানো আছে
না লাগানো নেই দেখি না
Which paragraphs are relevant, please?
Certain markings are there if
against you. Markings
no.
are against you or in your favor?
To some extent my favor and others are denial. May I read out only two paragraphs, my lord?
Yes.
With reference to paragraph said petition, I deny dispute that plaintiffs is in possession as well as at all. Admittedly, the defendant is in possession of the said properties as alleged or at all. The question of threats as such the entering the suit premises or receiving the notice cannot and does not arise. It denied a dispute the defendant by reason is in corporate status likely to page 10, my lord will find. 100 বার.
Page 10, yes. Paragraph 8. Yes.
Persons like to do wrongful acts or alleged at all. It is denied and disputed that the plaintiff stands to suffer loss and injury as alleged at all. Denied and disputed, and such as a plaintiff not as defendant was trying to enter the property as alleged at all. Similarly, the suit was filed in 2015, and false allegation of encroachment is made in the application on July 2016. The question of the plaintiff raising any objection to such law, false incident could not and did not arise. Clearly, the alleged complaint of the plaintiff will be before the police on the usury basis.
So where is that? They have said that they are in possession and how?
Yes, that your lordship will find.
শুরুর দিকেই হবে
And turn to page 6. Paragraph PQR, your lordship find.
Is the ownership 1955?
And
Where is 1953?
paragraph F.
Paragraph
F. Furthermore, the said deed declared upon by the plaintiff records that the settler named
1953.
records
So,
9 decimal out of 18 decimal.
so no right title interest in the said plots.
The property of the domain and the have been
In title and possession, plaintiff had by an undated letter is in possession. Upon examination of the referred to lawful control, plaintiff had no right title and interest. Defendant lawfully declined to accept, mislead the court. No, mutation and other things have been stated here. Yes,
Yes.
has stated above, recorded in the record of rights.
According to the record of rights. So if he is in possession, he can produce by way of documentary evidence.
1955. Yes. Yes.
Therefore, my lord, he is based on documents. The construction and other things will not should not find over here. Be as it may, his claiming is that by way of deed, he became the owner of the property, he is possessing the land, his name has been mutated for the purpose of showing possession. He will produce the record of rights for the purpose of showing possession. He stated that yes, he has all those documents with him. So what I put this was, what is the necessity for local inspection? What elucidation can be made to the court below? As of this day, whether this 37 can be attributed for this purpose or not. Keeping aside the judgments which my learned friend cited are all the proposition of law that if the court thinks if it is disputed, it can be done.
Any decision you want to rely upon, Mr. Rai?
I can only the decision.
Which decision of Calcutta you said you are pursuing? Show me. 78 Calcutta. 78 Calcutta.
Without any evidence. Well, that is the way.
78 Calcutta. Yes, give me that.
Fishing road. This is nothing but fishing road evidence.
And 61 Supreme Court.
Well, these are the judgments, well, off-court judgment of the Calcutta High Court judgment.
61 Supreme Court you have not brought, Mr. Rai.
Well, still we are
This function can be delegated to the commissioner or
delegated to the commissioner. My lord's judgment is there. I find it that also those two judges are considered by your lordship in rejecting the application for this purpose. This is
Let a one line reply with my learned senior friend is concluded. My learned senior friend is arguing on Milord point number 3 of Milord my schedule at page 60. Milord, I have given up 3. Kindly Milord turn to page 60.
No, yes.
Milord, my learned senior friend was arguing on point number 3. Who is
you are on point number 1 only.
Local features. That's it.
This application under Article 227 of the Constitution of India is 330 resolution is there, Mr. Rai.
My lord has kept a supplementary.
You want to violate your own resolution? All right.
One urgent matter was fixed at 3 p.m., my lord. Can it be fixed on 19th, my lord?
It was continued prior to 3.
Clerkship, under compelling circumstances, I am clerkship.
Hey, mention matters below. 6. Yes.
Section 6 allowed. With respect
Yes.
to refrigerator scheme,
Hand over possession, Mr. Rai.
I was there since 1986.
You were there, you are not now.
No, I am now. According to them, I have evicted by the
Illegally entered into possession. Section 6, Mr.
No. Section 6, you logically consider what is the ground for order impugn, my lord, if you logically consider.
বলে দিলাম তো মাঝখানে judgment.
Impugn, my lord, can turn to page 9 of the impugn order. Supplementary.
Where is the finding that this suit was filed within the period of limitation? Nothing.
Nothing. That is where page 9.
Mr. Rai, so many pages order. 12
pages order.
12 pages order, no finding.
Title decided. Exhibition constitution decided. What is the data extra discussion? The prosecution Peter 1 also scrutinized by this
Which
court.
page? Which page?
Internal page 9 of, at the bottom, my lord will find the running page number.
Yes.
The middle portion, the constitution of plaintiff Peter 1, my lord got it.
Cross examination, yes.
Considered by the defendant, the Peter 1 had most of every suggestions of the defendant, but affirmatively said in his constitution that he used to reside at 495 in our colony, Kolkata. Actually, before he came to reside in the suit premises at Sansad. He further affirmatively said in his constitution that he came to reside in the suit in 1984. But further in the further in his constitution, he admitted he cannot show any document to effect his occupation of the suit property by him in the year 1984. Entry failed to produce. Now, I can turn to next page.
So what is the date of disposition?
Nothing.
What nothing?
This time is a particular date has been given. That
Yes, yes. What is that case?
That is the date is on.
How you enter into possession, Mr.
I was there. If you logically consider the got a case that I have not in possession. The property originally belongs to one Mollika, who transferred the property in favor of me. These are the documentary evidence. May I hand over a copy to your lordship? Itself, if it. Your lordship find the refugee rehabilitation department have granted the settled the plot in favor of the transfer of the petitioner. After that, your lordship finds the deed itself. Srimati Ranubala Kormokar got the property from.
Which page?
The deed, my lord.
Yes, deed I have got.
Yes, at the top, your lordship finds.
Oh, you have folded it. This page.
Yes.
Thank you. Thank you for folding. Yes.
Your lordship is Gohita, Srimati Ranubala Kormokar.
Yes. Yes.
And who was transferring the same, my lord, Mohama Molli. Mohama Molli, my lord, got it.
Yes.
Now, my lord, can we see the property was settled in favor of Mohama Molli by the government. The document I have.
Mr. Rai, show me that issue with regard to prior possession within 6 months. Which issue was that? Up to whether the plaintiff was it? Show me the finding on issue number 3. 3 and 4. So date of disposition is 13/11/2011.
According to the.
According, yes, show me how that was decided.
Yes, I'll start the internal page.
Internal page 10. Issue number 3. Issue number 2, 3, and 4 was being decided. Yes. Show me that finding with
C denied that other side is the forceful ouster of the plaintiff from the suit property. Thus, to summarize from the oral evidence DW1, it remains the option of this court that the defendants have a separate
which portion you are placing, Mr. Rai?
internal page 10, thus
Internal page 10.
third paragraph from the bottom.
The evidence of DW2.
Yes.
No, that to summarize.
That.
That to
summarize.
That to summarize. Yes.
Oral evidence DW1, it transfers the option of this court that the defendants have a separate place of residence than that of the suit property. So while it is admitted that this suit property is also my residence. They even admitted that forceful eviction of plaintiff of the suit property. Well, from where it came to court.
Admitted.
From what I put this question myself, where is that evidence of that score? This possession of the suit property just immediately before accused of cause of action as stated by the plaintiff that evidence DW2 is the staffer of the concerned ADSR office is registered title of the mother of the defendant has come to depose here in the title of the plaintiff. This oral evidence has been looked into, but the same is not required to be detailed as the title of the plaintiff is not the challenge not relevant herein. I am having title to my mother who has been gifted the property, and it is not a case that the plaintiff has any right and interest over the property save and except that he is in possession. On the contrary, I produced the documentary evidence, my lord, you are notified, it is of that property. From 1986,
Sir, this is like a first appeal.
First appeal, my lord, LCR called for. Also.
Those days are over, Mr. Rai. No LCR to be called for now. Online, it's been transmitted. Physical copies will not come.
No, that's it.
Yes.
Supplementary list.
Supplementary publish করেছেন? Yes.
Supplementary item number 1.
Supplementary লিস্টের মামলা এটা।
Mr. Onamitra Banerjee will be appearing for the opposite party matter.
In which matter?
This matter, my lord.
Supplementary.
Outside the hotel, he's rushed to the hospital, my lord. Kindly keeps it documented.
কোন মামলাটা? আরে কোন মামলা?
Supplementary list.
কোন মামলাটা?
Rinku Dasar.
না, এটা প্রাইভেট matter। কিসের মামলা?
I have instructions.
This is a different matter।
আমি appear করছি তো। Supplementary list for the opposite party.
No, supplementary list. Please check up. We might have confused with
রিঙ্কু পাল ওই মামলাটা বলছে, তোমরা যেটা অ্যাপিয়ার করে বলছো।
this matter.
Yes, my lord.
Then
there is no caveat, my lord.
Maybe.
My lord, it will be implemented.
Mr. Chatterjee, there is no caveat.
I am appearing, my lord, Mr. Chatterjee. My lord, I will be disposed this. My lord, kindly see 1 minute. Thereafter, my lord, whatever 29 comes out, just take 1 minute. 29.
If he says that today he will be disposed, I am staying this.
I am representing, so Lordship takes it up. I am representing the opposite party.
Oh, you are representing the opposite parties.
My lord, kindly come to
for the petitioner.
Yes.
So you come here. So I thought that you are leading him.
No.
That is why I asked you that they are appearing, please.
My lord, kindly come to page 29.
Page
29. Last portion. Last portion, ordering portion, my lord. Just the first 31st July, this order has been passed.
Mr. Chatterjee, can you appear after 3:30?
Yeah. My lord, if he can, I can.
I will remember this.
Every day, I am here. Every day, my lord remembers. My lord forces us, and then my lord remembers.
You are
Lord,
forcing.
we are learning from Mr. Chatterjee.
You are forcing. What is the impugned order?
Kindly see, now the impugned order, they have moved an application on the next date, 1st August.
What is the impugned? What are you challenging?
My lord, execution, they have filed an application in execution that has been ordered that I should be break even the
Padlock.
Break even the padlock.
Even
open.
Break even. But so the decree, have you challenged the decree?
2 months time period has been even 31st August and 31st July, the decree passed. 1st August, they move an application. Last order, my lord. Kindly see the 1st order number 33. My lord, they record the order that 2 months time period has been given.
Show me the by which 2 months time was given. Show me that.
My lord, ordering portion, page 29.
Ordering portion, page
29, my lord, of the decree. Last portion, my lord.
2 months. 2 months is
from September 31st July. This order is. Now kindly see the order.
July, August, September. So 30th of September.
Yes, my lord. And
yes, Mr. Chatterjee, how can you do this?
20th August, my lord, it will be disposed. How is it possible? Well, my right.
How can you do this? 2 months time by the appeal court's decree. How can you do this?
My right. 20th August.
Because this.
2 মাসের মধ্যে যদি না ছাড়,
if self was allowed, how can it be?
However, cost is exempted to be paid if peaceful cash possession is delivered.
How can this order be passed prior to 30th of September?
But I am challenging this. I will be challenging this.
This is under challenge.
But
This order is not a
yes, 1st of August. This is under challenge.
August.
appellate court.
Appellate court gives them 2 months time. Title appeal decree.
Yes.
Yes. Title appeal dismissed.
However, if
yes.
He pays 50,000 rupees, then
No. Otherwise, right. But I do not have to pay.
No, Mr. Chatterjee. Let us. Yes. Let us not go into that. When this decree was passed,
31st July, my lord.
So 90 days time, they have a right to prepare an appeal. 90 days time, Mr. Chatterjee, they have a right to prepare an appeal. 90 days time, they have a right to prepare an appeal. How can you frustrate that? So how can you frustrate that? They can even file on the 90th day. How can you frustrate that, Mr. Chatterjee?
But then, my lord, there's one aspect to that.
Mr. Chatterjee, no, this cannot be done. This is taking away the right of appeal.
Then they will have to put in, my lord, the occupation charges.
That, Mr. Chatterjee, that's a very different thing altogether. That's a different thing altogether. They will have to pay for stay in the second appeal. There is no appeal now.
They have not preferred any appeal.
But they have a time till 90 days. So how can you insist paying of occupation charges prior to that?
This was filed, my lord, because the decree was the original decree was passed in.
Maybe the appeal court gave them time and may not, Mr. Chatterjee may not. Let us forget that the appeal court has given them time.
Itself has already been allowed.
How can you take possession because they have a right of 90 days to prefer an appeal? Can you frustrate a right of appeal?
They have a right of appeal if a police help is allowed.
No,
to
no,
do
no. That has to be stated. No.
That doesn't mean below the 90 days.
Yes, no.
Has to go. The
Yes.
police help order has not been challenged.
That is under challenge.
No,
That is the first of August.
Under challenge.
This is 1st August order under challenge.
First of August is under challenge.
Have a look at it.
1st August order.
First of August.
First order challenge.
Not the order. Act second. One second. Allow. Your favor. I
ঠিক আছে দাদা, ওকে দাদা, ঠিক আছে দাদা, তুমি বুঝতে পারছি, শিখছি দাদা।
Just give me a second. Kindly look to the order once.
First of August order.
1st of August.
Yes.
Lord, if your lordship sees the ordering portion,
Yes, ordering portion.
rather comes back to the below the considered. Perusing the instant petition and other materials on record, it appears that
No, where are you placing? Yes, perusing. Yes.
From the petition so filed from the decree holder for breaking open the padlock, the court is inclined to observe that it may not be really practicable for the court very to execute the writ without breaking open the padlock of the disputed property. In that event, the court believes should be empowered to execute the writ simply by breaking open the padlock of the decreed property if the situation so demands. It appears that the decree was passed on 13th August. Almost a year has been passed.
13th August 2024.
The first court, first court, that is not the appellate court.
Right on this.
First court's order.
You are right on that. I'm not going into that. The court is of the considered view that there is no illegality in instant application is allowed.
Appeal court's order not considered, Mr. Chatterjee.
Well, it was recorded in the first part. It was recorded. It was not a.
What is that?
This is the police help order.
দাদা আমাকে একটু দাও।
Yes. This was allowed, my lord, on 16th of May 2025. This order, my lord, is not under challenge.
No, 16th of May 2025. At that point of time, the appeal was pending.
Yes.
My lord, the appeal might have, there was no stay. There was no stay.
My lord, possibly
There was no stay in the appeal.
No. My lord, kindly come to page 14.
Mr. Chakraborty, was there any order of stay or no?
I have annexed that stay. Page 14. Page 14. No. Meanwhile, should be there stay on the execution case. Page 14. Kindly see.
14th of July.
তারপরে দেখো পরপর সব ইয়ে হয়েছে। Kindly see from page 14.
Stay of execution is there.
তারপরে দেখো। This is the বর্তমান
No, then this.
My lord, kindly.
Then how
14 July, it is against.
Then fix it on Monday, my lord, I'll take full instructions and come back.
No, my lord.
Mr. Chatterjee, but
My lord, kindly see.
he was there in the appeal court.
But on 16th of May, my lord, police
My lord,
have
How? Cannot be.
My lord, after
Mr.
that.
Chatterjee, this is Ashun.
কি বল দেখো জুন মাসে এই তো স্টে আছে দেখো তুমি মিথ্যা কথা বলবো না 25 জুন 20 দেখো স্টে
Yes, 22 June.
yes মানে there's a
This is an
stay
order passed on 16th of
but
May.
after that the court has stayed
No. This is wrong.
This
My
is
lord, he should be right before your lordship. On the day, my lord, of 16th of May 2025, there was no stay. The stay happened later.
All right, you take instructions. I am saying when the possession is being taken.
but it will be taken up any day no but day 20th is the
I'll
next
keep
day
it in the next week, you take
Then
instructions.
fix it on Monday or Tuesday.
Monday no my lord Tuesday they will not allow me to file an appeal
Have you obtained the certified copy?
my lord I was not served with this copy of the application when I was taking
No. The decree in the appeal.
My lord,
Judgment, have you got the certified copy?
yes my lord I have got I will be
When you will be filing the appeal?
my lord by next week by next Friday or by the Monday week I will be filing by
Well, Mr. Chatterjee, I am doing the, I am staying it for a limited period. So let them, because they want
But
to
I have
file
a
an appeal
90 days
within the
time
next week.
period.
In the next week, they will be filing the appeal.
No, that's one aspect. But if the order of police act is not challenged, that attains
Mr. Chatterjee, when? Maybe not challenged, but an appeal, order of appeal has been passed.
They will have to go to the
May
appellate
not,
court and face the
Mr. Chatterjee may not be at that, but even if your submission is accepted,
Lord, I
when
say-
the order of police help was allowed, let us accept for the present, there was no stay. But thereafter stay was passed by
They
the
have
appellate
been-
court.
Lord, now what happens? is
Now
they
the
have to go
question
to the
is,
second appellate court.
yes,
They will
but
have
for-
to go to the second appellate court and grant.
yes, for that I am giving them breathing time to go before the
This
second.
order is not wrong.
So they have to get a breathing time to apply.
Was all there, was whatever he has, he can file a
Mr. Chatterjee,
and get it heard.
they have a right, Mr. Chatterjee, they have a right to challenge that.
They have not. They have not exercised.
They have a time of 90 days.
Even then, they have a time here also.
What?
They have a time below to file the revision application. They don't have a time to file the second
That,
application.
Mr. Chatterjee, 90 days time is there.
My respectful submission. I don't even have a copy of what they say. Take it for instance, Vinod, that at that point of time there was no stay. And it's on record, there is no stay. Now, if there is no stay, the police help was granted. Once the police help is granted, Vinod, their right of appeal is still there. Their right of appeal is what, Vinod, they are Vinod, supposed to exercise. The right of appeal they have not exercised. They are saying that I will do it sometime later. Now, today, Millard, for this to stay, for your lordship, Millard, to interfere, Millard, with this order has to be wrong. This order, Millard, doesn't give them breathing space. I understand that it doesn't give them breathing space. When the order is passed in the second appellate court, before the first appellate court, Millard, the order of police was there. They could have stayed that. Was not stayed. They were given 2 months time to vacate. Very well. That's another part of the Millard story. If they put in 50,000 rupees cost.
No. That is a different exempting from putting in.
Yes.
That is a different thing altogether.
Vacate them 2 months and
They-
no question of Millard. What my submission is, the stay that your lordship is granting, not in my respectful submission, this needs to be granted by the second appellate court, by the division bench. If the appeal is to be preferred before the division bench, not with a lot of respect, not the single bench, that judgment, not the age-old judgment, the single bench would not interfere. The appellate provision not exercised. They have not gone to the second appellate court. If they could have filed this revision application, the second appeal could also have been filed. There is no appeal.
All right. Ashwin, this application under
the same of possession and challenging the same itself.
From tomorrow?
Is a Independence Day. Your lordship would be somewhere there. But I don't have a problem.
কালকে কোর্ট হলে অসুবিধা
Your
কি
lordship
আছে?
sits on the Independence Day. I have no problems at all. From on Monday, but at the morning.
It's under the heading fixed matters.
It's at 3 o'clock.
It will be taken up. Mr. Chatterjee, now I am in the difficulty. Because some are saying these matters, you also are saying matters in the supplementary list are not being taken up. And some want that the contested application also to be taken up. So it's the best time to tell all of you, please, Mr. Chatterjee, I do not have any difficulty in taking up contested application. You can also pick the time. According to your convenience for taking up contested application, I tell you that I can take up contested applications from 10:30 also.
I consider that before 1 month before the
That
contested application. There is a bench for contested application. There is no bench for second appeals. But there is a bench for contested application.
I do not know you come on any Wednesday, on other days also, contested applications for myself, because it has been told that I am not being taken up. I can take up. I do not have any difficulty. I leave it to you. You fix a time limit. When to be taken up contest, I will take up contested applications. But I will proceed with the serial.
I'm not going to say that. If the bar collectively says something, that's a different thing.
That is why I am telling you, but for you personally, it's for the bar. You tell me no difficulty. You tell me when to be taken up. Because if I take up those 6 matters, then motion, because I know my capacity, I cannot proceed that fast. So I know my limitations, how far I can proceed. So if I have to take up those upgraded matters, the motions, some motions cannot be taken up. So
Motions will not happen.
some motions in the supplementary list which are going way down, you are saying that is to be taken up. These two cannot be balanced at the same time.
Here there's some urgency like the other matter.
All right, so it will appear 3 p.m. It will appear, because today I do not know on Monday he will also take a resolution or not. That I do not.
মানবে কেন রেজলিউশন কেন?
ছটা বাকি আছে।
No, এখন অনলি শুধু ফ্রাইডে নিচে দল
না না
তাই ও তাই
If Monday it's not 3:30, then 3 p.m. it will be
Mr. Chatterjee,
But before your lordship, because they called us in the morning with respect to possession, they called us by and they called us in the morning for possession. That's why you are saying
Till that this matter has been fixed,
Lord,
this is bad.
thing will happen.
Lord, item,
Is that
Lord, item 20,
supporting you?
No,
He is there.
challenging the same.
He is there. Please see, because
Lord, item 228 marked for 3 p.m. today. Will it be not marked as well for Monday? Kindly not take it up on Monday. It's marked for 3 p.m. My lord, after a lot of mentioning, fix the matter.
you fix the which matters to be taken up when.
According to your lordship, I already fixed it for 3 p.m. today.
Yes,
Because due to paucity of time, it could not be taken up. Lord, let it be marked also for Monday, Lord, so that Lord, it could be taken up. Only that, Lord.
I am
Tuesday.
your lordship. Your lordship has passed the order on 4th August 2025. Lordship was possibly not pointed out. There is a caveat pending when the application was filed, my lordship. I filed a caveat on 3rd December. Your lordship, they are filed an application for revision on 5th December, my lordship. And
There was a caveat noting.
yes, lordship, we have filed
Order হয়ে গেছে?
caveat, lordship. But we got a stay.
And over the sleep, what are 2 mentioned at the advocate for the petitioner.
অর্ডার হয়ে গেছে নাকি আপনার বিরুদ্ধে?
Utiman Chatterjee, lordship.
Utiman
Chatterjee or Banerjee?
Banerjee.
Yes, where is Mr. Partha Pratim Rai?
কি অর্ডার হয়ে গেছে আপনার বিরুদ্ধে?
Got a stay order till December, lordship.
2 mentioned দিয়ে দিন।
Lord, may I make a
তুমি কি আমার recalling lordship, and we have filed
Alright,
send a application to them, lordship.
Alright, can one টা দিয়ে 2 mentioned দিয়ে দিন একদম।
Lord, Mr. Mukherjee, opposite party, he says that Monday there will be a 3:30 also. Keeps my matter on Tuesday, Lord. No, you just. তো দেখো ওই কি রে ভাই দিন তো কোথায় ভরসা করা যাবে না
That party also.
Tuesday, 2 p.m.
540 lordship at the matter, my lord.
আমার
My lord, in a rainy season repair application rejected only on the ground, my lord.
My memory is very short, Mr. Chair. Mukhaj, I cannot. That you know you have admitted.